Worship, I will be permitted to mention company number 1191 of 2020. We have filed a stay petition that writ appeal. WA 1191 of 2020. No, sir, it is for inclusion. Your Lordship, there is an emergency because they have initiated a disciplinary proceeding, gone ahead with a disciplinary proceeding for which memo of charges was filed 11 years back. And that was also quashed by this honorable court by a single judge bench, which has been challenged in appeal by the opposite party state. And now they are proceeding with it. The next date of appearance is tomorrow.
We pardon to make a mention of this. In the second half, my lord, item number 6, CRL.
My lord. My lord, this is out of the list mentioning for listing of 2 contempt petitions arising out of my lord's order in September. This is that IAS promotion case, my lord. Deeply obliged.
Supplementary list, item number 1.
No.
Item number 2.
May I please, your lordship. Lord, in this petition, the petitioner has challenged the judgment order dated 15/11/2023, passed by the Learned Central Administrative Tribunal. My lord, the main issue involved in this case that whether pre-appointment training period can be taken into consideration for MSCP. My lord. My lord. Yes, my lord. The judgment of my lord. The judgment of my lord. He further submits that the issue involved in this case has already been answered by a division bench of this court, and this has been confirmed approved by the Honorable Supreme Court. The judgment of this court in so and so case decided on 1/5/2017 has been annexed as annexed A/11 to the original application. The order dated 12/10/2019 passed by the Honorable Supreme Court in special petition diary number so and so Union of India and others versus Ashok Kumar Bhavik is annexed as annexed A/13. My lord, I will clarify your lordship. Those judgments has been delivered in a different context, my lord. Union of India. My lord and friend is there for the respondent, opposite parties. Prior, my lord. My lord. Yes. My lord. It is page 32, my lord. Page 32. The way was filed by the opposite parties, my lord. My lord.
That is really short for okay, that is in page number 50, paragraph number 8.
Yes, my lord. My lord. To quash the speaking order dated 18/8/2021 under annexed A/17 and to direct the respondents to compute the in-service post-appointment training. This is very important, my lord. And direct the respondents to compute the in-service post-appointment training period as qualifying service for grant of financial upgradation under MSCP scheme for junior engineers and senior section engineers of East Coast Railways, and to direct the respondents to antedate the financial upgradation granted to the applicants under MSCP scheme in view of the computation of in-service post-appointment training period as qualifying service. My lord, this is very important. Your lordship may AY 17, my lord. My lord, that is the speaking order, my lord. My lord, I am coming.
Filing the original application, filed the day by
Yes, that has been filed. My lord, that is filed by my learned friend, man.
155, man.
155.
Order.
Yes. That was passed by the Vishnu Prasad Das. Yes.
General Secretary.
East Coast Railway Engineering Association.
Presentation was filed.
Yes.
That representation dated 3/12/2019, and that was in compliance with the order passed by the council. Yes. Then what has been done here? What has been done?
My lord. My lord, kindly come to page 157. 157. In that order, my lord, internal page 112. Second para. It has also been clarified by the Railway Board by letter number so and so, dated 29/10/2015, that training period would not be counted for. My lord, this is the railway clarification letter. Yes. Page, my lord, 157. 157, my para 2, my lord. Para 2. It has also been clarified by, this is the clarification given to the, my lord, opposite parties, that it has been clarified, it has also been clarified by Railway Board by letter number so and so, my lord, dated 29/10/2015, that the training period would not be counted for the purpose of any financial upgradation under MSCP. Further, Railway Board by letter dated so and so clarified that dated 17/1/2012, clarified that pre-appointment training shall not be taken into reckoning for the purpose of MSCP. In view of the aforesaid, that was the order. Their prayer was not considered, my lord. Thereafter, your lordship kindly come to the railway notification on MSCP, my lord. That,
this order was challenged before the central administrative persons.
my lord.
The speaking order.
Yes.
Apart from other regulations.
Yes.
So what was held by the running central administrative persons?
My lord.
In the order, order under Annexure 1.
Annexure 1. Held, my lord.
Already.
Yes, my lord.
Page paragraph number 6, page 40.
My lord. My lord.
Paragraph 6 now.
Paragraph 6. Having heard learned counsel for the parties and after going through the records, this court finds that since the claim of the petitioner for grant of SEV has been adjudicated on merit and the decision of this court has been confirmed by the apex court in SLP number so and so, there is no valid and justifiable reason on the part of the Central Administrative Tribunal, Cuttack Bench, Cuttack, to reject the claim of the petitioners on the ground of delay and laches. In the above view of the matter, this court disposes of this matter of this writ petition on the basis of the observation made in paragraph 4 of the order dated 27/2022 part in WPC number 13677 of 2018, which are extracted below. My lord, on a perusal of the impugned order, it is seen that Learned Tribunal has passed the impugned order relying upon the decision in OA number 192 of 20190, which has been confirmed by this court in WPC number 12425 of 2012 and also by the apex court in SLP number 11040 of 2013. The operating portion of the impugned order is extracted hereunder. The above point has already been settled by the decision of the tribunal dated 22/3/2012 in OA number 192 of 2010, as the same has been upheld by the Honorable High Court by the order dated 6/2/2013 in WPC number 12425 of 2012, and thereafter the matter on being appealed of the SLP number 11040 of 2013, the Honorable Supreme Court dismissed the same by the order dated 2/8/2013. Following the above decision, this tribunal later on also granted similar relief to applicant in OA number 41 of 2011. Therefore, in our considered views, the point in issue being set at rest, we have to have hesitation to hold that the period spent under training till the date of regularization of service is reckonable for the purpose of grant of first financial upgradation under the SCP scheme. Accordingly, we pass the impugned order dated 9/1/2014 and direct the respondent railway to reconsider the claim of the applicant for grant of first SCP on completion of 12 years since from 8/4/1988 by conducting a review screening committee meeting and subject to fulfillment of other conditions, he be so granted with consequential financial benefits. My lord, this was the my lord. Issue urgent. My lord, in view of the settled law quoted above, it is held that the applicant is entitled to count their qualifying service for the purpose of financial upgradation under MSCP with effect from their respective dates of joining in training after being qualified through RRB and joining in the post on the successful completion of training. Accordingly, the impugned order of rejection dated 18/8/2021 is hereby quashed and the respondents are directed to revisit the grant of financial upgradation under MSCP by counting the qualifying period of 10, 20 and 30 years from their initial date of joining and accordingly fix their pay as per rules and pay them differential amount within a period of 180 days from the date of receipt of a copy of this order. My lord, in that, my lord, Honorable Supreme Court, first, my lord, wave, your lordship kindly have a glance, page 34. Page 34, my lord, last para. It is profitable to place reliance on the decision of this tribunal in OA number 192/2010, Chittaranjan Mahanti versus Union of India and others, disposed of on 22/3/2012. Page 34, my lord, of the brief. Yes. Last para. It is profitable to place reliance on the decision of this tribunal in OA number 192/2010, Chittaranjan Mahanti versus Union of India and others, disposed of on 22/3/2012, upheld by the Honorable High Court. Those decisions, my lord, again referred to, came to this Honorable Court. Thereafter, that was confirmed by the Supreme Court. The operative portion, my lord, the next para in page 35. This was objected to by the learned counsel for the applicant on the ground that the applicant was appointed as a trainee artisan in a particular scale of pay. He has been granted annual increment since 29/3/1998. My lord. Yes. Last 6 lines. We have paired the serial number 109/92, where under the railway have decided that the period of training will be treated as a duty for the purpose of grant of increments to those railway servants who have undergone such training on or after 1/1/1986. My lord, here, my lord, that period was treated by the department as they are in duty, my lord. Hence, my lord, that was considered that they are in next, my lord, in the page 36, next page, my lord. It has been held. My lord. My lord.
Which was confirmed by this court, also by the Honorable Supreme Court. This is another such matter.
My lord, may
Why do you interfere with this?
my lord, why, my lord? The judgment given by the Honorable Supreme. My lord.
That the substitution made by this court was also confirmed by the Supreme Court.
My lord, not incorrect, my lord. My lord, I am not impress your lordship that order is incorrect. That was given in a.
By the judgment.
My lord.
That assumption was incorrect.
My lord.
So it was
That,
not actually covered by this judgment delivered by this court, which was confirmed by the Supreme Court.
my lord, that was given in a different context, my lord. That I am. My lord. My lord.
How is your case is different?
My lord, this paragraph.
Just come to the prayer. It
My.
is made in this particular way. This way, the applicants are challenging the rejection that is made by 72 is also 18/8/2021. In denying them, so count the qualifying period of service for the purpose of granting them financial obligation under the MSCP scheme with effect from their respective dates of training. Before being appointed, after successful completion of training in the post, against which they are self responsible. So, is it a case, is it your case that the earlier application, way application, which has been mentioned here, which was come to this court and also to the Supreme Court, if they are something different, the parties, prayer or the facts and circumstances of that case is totally different.
My lord.
You know, it's Central Administrative Tribunal here that it is almost identical.
No, my lord, because your lordship, in
that case, also my prayer was to count the in-service training period as qualifying service, my lord. Tribunal for first time in OI number 192/2010 allow a repetition preferred by the present respondents, my lord. My lord. May I pray, my lord? In spite of dismissal of writ petition and SLP, they contested a matter, a judgment delivered by this court, my lord. Your lordship may kindly give a glance that judgment. Page 127, my lord. A batch of writ petitions, my lord, filed by the present respondents. They lost the matter here, my lord. This honour court decided the issue in favor of the employees. Against that, they prefer SLP. SLP referred to a full bench, my lord. Honorable full bench of Honorable Appeals Court dismissed the specially petitions filed by the present respondents, my lord. And that dismissal order of Honorable Appeals Court is available at page 147, my lord.
They're confirmed by the Supreme Court that has been treated there.
My lord.
Para to first read petition ওই লেখা হয়েছে 192 of begin page number 34 that was offered by this court in WPC number 12425 of Johnson's in Apex Court in SFT. And another way 624 of 2013 begin offered by this court and Honorable Supreme Court 2 years ago. Now we see
My lord,
192 the observation to the agent will provide the respondent are related direct to the bound the period of service to also for the purpose and allow the applicant
Batch of writ petitions
My lord.
preferred by Union of India with regard to self-some issue were dismissed by the common order.
and confirmed by the also the
My lord,
Supreme Court.
my lord, that my friend is impressing your lordship the order passed by Honorable Supreme Court 147. Your lordship
No,
kindly
come
have
to the judgment passed by
Yes,
this court, common
yes,
judgment.
My lord, kindly have a glance for a moment. 147.
Para 2,
Page 47. Yes, page 47. My lord, what is the
page
observation?
47,
Page 147.
147.
147. The judgment passed by
all
the
the earlier order passed by the Central Administrative Tribunal in different way that were the same direction was issued
My lord,
to provide that to grant a CP in favor of the
yes,
petitioner.
my lord, kindly.
And that was confirmed by this court and the Supreme Court.
Yes, my lord.
And again,
My lord,
this court also
Yes, my
the
lord.
same.
What is the observation of the Honorable Supreme Court? Your lordship kindly have a glance in the page 147, last para. We find, your lordship
Yes.
found it. We find no ground to interfere with the impugned orders passed by the High Court on the ground that the petitioners were given the regular pay scale and the increments were also given to them right from the day one.
All right.
Even during the training period,
Even during the training period, increments were given to them. We have considered the policy pertaining to ACP on perusal of the same. We find no ground to my lord. But they were treated as the regular employee.
All right. The petitioners
My lord, your lordship.
filed this petition challenging the
Your lordship,
order dated
my lord,
1511 please 15/11/2023 passed by the London Central Administrative Tribunal in OA number 485 of 2021. It appears that the opposite parties numbers. Who are the opposite parties who filed the original application?
my lord, different persons, different date of my lord.
The association has filed the.
It appears that the East Coast
Railway Engineers
Association in this writ petition is opposite party number one. Then also the this Modawa is there opposite
They are
party
the
number
members and the executive body members.
along with the members and executive body members, right? Approach the London Central Administrative Tribunal Cuttack Bench Cuttack in OA number 260/00485 of 2021 with a prayer challenging the order of rejection dated 18/8/2021 in denying the claim of the applicants to count the qualifying period of service for the purpose of granting them financial upgradation under MACP scheme with effect from their respective dates of training before being appointed after successful completion of training in the post against which they were selected through Railway Recruitment Board with a further prayer for a direction to the respondents in the original applications who are the petitioners in this writ petition to compute the in-service oblique post-appointment training period as qualifying service for grant of financial upgradation under MACP scheme for junior engineers and senior section engineers of East Coast Railway, to antedate the financial upgradation granted to them under MACP scheme and to pay the differential arrear salary. The petitioners, who are the respondents in the original application, filed the counter affidavit, and it was the case of the petitioners in their counter affidavit that the petitioners are the applicants are not entitled to get such benefit. However, the Lenin Tribunal found that in OA number 192 of 2010, Chittaranjan Mahanti versus Union of India and others, which was disposed of on 22/3/2012, upheld by this court in WPC number 12425 of 2012 by order dated 6/2/2013, and by the Honorable Supreme Court in SLP number 11043 of 2013 by order dated 2/8/2013, and subsequent OA number 924 of 2013 in case of Parshuram Naik versus Union of India, disposed of on 7/4/2016, upheld by this court in WPC number 19250 of 2016 by order dated 8/3/2017, and confirmed by the Honorable Supreme Court in SLP public diary number 23168 of 2017 by order dated 15/9/2017, and number of writ petition like WPC number 19250 of 2016 bracket UI and others versus Parshuram Naik, WPC number 16565 of 2016 and other batch of cases, Union of India versus Bhagwan Mishra, disposed of by order dated 1/5/2017, and which was challenged before the Honorable Supreme Court in SLP number 28896 of 2019, and WPC number 27118 of 2011, disposed of by this court on 6/12/2012. The issues have been already settled. Accordingly, it was held by the Land Central Administrative Tribunal that the applicants are entitled to count their qualifying service for the purpose of financial upgradation under MACP with effect from their respective dates of joining in the training after being qualified through RRB and joining in the post on their successful completion of training. Accordingly, the rejection order dated 18/8/2021 was quashed, and the present petitioners, who were the respondents in the original applications, were directed to revisit the grant of financial upgradation under the MSCP by counting the qualifying period of 10, 20, and 30 years from their initial date of joining, and accordingly fix their pay as per rules and pay them the differential amount within a period of 180 days from the date of receipt of the order. Mr. Karunakar Naik, Land Council, Land Senior Panel Council, appearing for the Union of India and others who are the petitioners in this writ petition, submit that the issues involved in the earlier original applications, so also which were confirmed by this court and so also by the Honorable Apex Court, are different than the present one, and therefore the London Central Administrative Tribunal was not justified in relying on the findings of those original application writ petitions, so also the observation made by the Honorable Supreme Court. However, after going through the nature of prayer sought for in those original applications, so also the order passed by this court in different writ petitions and the SLP orders, we find that the submission made by the London Council for the petitioners is not acceptable. There is no infirmity or illegality in the impugned order, therefore we are not inclined to interfere with the same. Accordingly, the same is dismissed.
My lord,
Yes,
this
next
is a
one.
policy decision of the railway.
Yes, item number 3.
Item 3.
To meet the query of my lords regarding execution of the lease deed, the petitioners are applied for RTI to obtain the information regarding execution of the lease deed.
Have you gone through the order dated 6/3/2025?
Pardon,
Have you gone through the order dated 6/3/2025, which we dictated in open court? Please see that.
Yes,
Please read it now.
yes. It's better, some time will be given to obtain the information regarding execution of the lease deed. That is the vital aspect.
That is exactly what we asked you to do the same. The order is very clear in that aspect. So you have not yet obtained instruction.
No, Mila.
How much time you further want?
On 21st of this month, I have applied. 1 month.
1 month.
One minimum required
All
for.
right, Mr. Banamali Sahoo and counsel appearing for the petitioner submits that he wants to obtain some documents sold to the instruction as per the order dated 6/3/2025, and the matter may be taken up 4 weeks after this matter, 2nd week of May 14th. Yes, 2025.
Item 4.
And the petitioner is a project displaced family. Well, considering their status, the opposite party has allotted a piece of land in view of resettlement policy. By the Annex 3, ROR issued in favor of the mother of the petitioner as well as the present petitioner. Well, in 2012. In 2012.
Okay.
2015, the mother of the petitioner died.
Yes.
And thereafter, the petitioner approached that land should be allotted and delivered in favor of the present petitioner, other legal heirs of the deceased allottee, and the PDF benefit matter, which is not yet considered.
No. Who are the legal heirs?
Legal heirs, my lord, paragraph 7 I have mentioned.
No, is it the legal heir certificate, page number 24?
My lord.
There are number of
My lord,
legal heirs.
I have mentioned in paragraph 7 on.
So why you have only come
my lord,
to get the benefit? Why you have left out the other legal representatives?
My lord, I have also mentioned
Legal
that
heirs.
all the legal heirs are entitled, but the petitioner has approved the authority to.
No, you have not even arrayed them as opposite party. Mother has died.
Yes.
You have filed the legal heir certificate.
Ma'am.
Page number 24 indicates
Yes, ma'am.
that who are the legal heirs.
Ma'am. I have also mentioned in paragraph.
It's all right, but in this writ petition, you have only come up that grant me that letter.
Only, my lord, since
so what about the other legal heirs? Are they not entitled to
yes,
get
ma'am.
it?
I have mentioned
why
they are
you,
entitled.
Why have you not made them opposite parties?
Because I have come before your lordship with a limited grievance to consider my representation. I
no. Then the order will be understood. They may consider that as if this court has asked them or directed them.
I will implement.
You implement them. Let's see that. This writ petition has been filed by the petitioner Govinda Nayak with a prayer to consider the grievance of the petitioner to deliver the land allotted by Khata number 494/898, plot number 421/4409/4605, area Eckerson 10 decimal and 494/899, plot number 421/4409/4606, area Eckerson 10 decimal of Mauja, Paranga under Chendipada Tahsil in the district of Angul, and to release the benefits as per the survey to the project displaced family in favor of the petitioner. You see, in favor of the petitioner, you have not stated that the in favor of the legal heirs of so and so. Not extending the benefit of rehabilitation and resettlement to the family of the land ousted. Averment has been taken that where have you stated that the land was allotted to your mother?
Paragraph 7.
Paragraph 7.
Paragraph 6, my lord. There are two khata, two plots. One is in favor of my mother, another is in favor of myself. Exclusively. In the paragraph 7, I have.
Just a minute. It is the case of the petitioner that the competent authority allotted an alternative land for homestead purpose in favor of the mother of the petitioner, namely Shahi Nayak. And the record of right has been issued in our favor by Khata number 494/898, plot number 421/4409/4605, area Eckerson 10 decimal, and Khata number 494/899, plot number 41/4409/4606, area Eckerson 10 decimal, in the name of Shabita Nayak, the wife of the petitioner, and Govinda Nayak, the petitioner, situated in Mauja, Paranga under Chendipada Tahsil. It is the further case of the petitioner that Shahi Nayak had died on 5/2/2015, leaving Govinda Nayak. Govinda Nayak is the petitioner.
Right.
Govinda Nayak, bracket like the petitioner, three married daughters, namely Shepati Nayak, Sauri Behra, Reboti Nayak, and 5 grandchildren, that is Parsuram Nayak, Prasanna Nayak, Prashant Nayak, Deepak Nayak, and Pratima Nayak as her legal heirs and successor. From the perusal of the death certificates, also the legal heir certificate, it appeared that the averments taken in paragraph number 7 is correct.
No.
However, we find that the other legal heirs are neither the petitioner nor they have been arrayed as opposite parties. And most peculiarly, the petitioner has prayed for the relief in his favor. When this aspect has been pointed out to the London Council for the petitioner, he intends to file an interim application for amending the cause title, so also the prayer portion of the writ petition. Put up this matter, says that he will file the interim application within a week. Place this matter immediately after the interim application is filed. Oh, yes.
Item 5.
Please, my lord.
Yeah.
My lord, here the petition is a landless person approaches the Tahsildar Baripada, opposite party number 4, that his representation is pending before the Tahsildar to settle the land in his favor. With all formalities, he has also applied the before the Tahsildar to settle the land under Original Act.
So, logically, representation settlement is
No, not only sir, representation. That is a specific format is available.
Where is that format?
That format Annex 2, sir.
Annex 2 is the format. It is under the OPA Act. Let us see that provision.
Sir, under section 8. On the other day also, my lord has verified that.
Order dated 23 March 2025, we have asked you, though the London Council for the petitioner has filed an application before the so-and-so for settlement of land.
Yes.
But in the said application, neither the date has been mentioned, nor there is any endorsement of any officers of the office of the Tahsildar Baripada. Land Council for the petitioner 6 time to file an affidavit as to when such application has been submitted before the Tahsildar Baripada.
That affidavit is here.
Where is your?
That is the affidavit. Okay.
Take it. Give you a copy.
Sir, sir.
Second copy what?
Sir, second copy. This is the second copy.
State को copy दिया हमने.
Sir, sir. Sir, we'll file in registry.
नहीं.
We'll file it in registry.
One copy of the affidavit as per the order dated 23/2025 has been filed in court today. The London Council for the petitioner submits that he will file another copy for the court to also supply a copy of the affidavit to the Land Council for the state.
In course of day.
You put up this matter in the week commencing from 7th of April 2025. Yes.
Sir,
Next.
Item 6.
Regarding giving employment to the members of the displaced family. Last day, the past ordered the state to obtain instruction on the representation, but there are identically placed matter where representations have already been rejected. So there is no point in directing disposal of representation or any order on the representation because they have already rejected in other similarly placed matter.
No, let him reject and challenge that order. The ground may be different, who knows.
So
what is your instruction, Mr. What is your instruction?
The instruction was not obtained. Only to their last occasion are directed to adjourn this matter to list along with WPC.
No. Please see the order dated 24/1/2025. There is a specific order that London Council for the state shall obtain instruction about the status of the representation filed by the petitioner before Collector Sundar Gaur Opposite party number 3 under annexure 8. The representation is annexure 8, page number 63 to 65. So
Then I may allow some time.
ଆପଣ order ଟା ଦେଖି ନାହାନ୍ତି କି? You see, they may take some ground for rejecting. So once it comes to them, they can file it, challenge it, amend the writ petition. Right. And so prayer is to be amended. Some grounds have to be taken also. So in this pending writ petition, Learning Council, Mr. Parija, you are
For OP number 6 in all the cases, we will file our call.
all right. No, just wait till the this instruction is taken,
Again.
and he may be also if necessary, he may amend also.
Again.
Thereafter, you file the.
Sir, OP number 6 or 7? 6. 6 is Shiva Cement. Status is
Cement is taken over by
Shiva Cement is the new lessee.
Shiva Cement is new.
Are Mr. Roth Land Council, senior advocate appearing for the petitioner, Sahoo, Mr. Parija, and senior advocate appearing for opposite party number 6, Mrs. Shiva Cement Limited. So, the Learning Council for the state submits that as per the order dated 24/1/2025, is yet to obtain instructions about the status of representation filed by the petitioner before the collector Sundargarh, bracketed opposite party number 3, under annexure 8, and the matter may be taken up.
2 weeks after that.
This order was passed on 24/1/2025. So virtually 2 months have passed. Have you made any communication?
Yes.
So why the collector has not responded to you?
One opportunity I leave.
We'll ensure the personal appearance.
In case of it.
The Learning Council for the state submits that in terms of the order dated 24/3/2025, communication has been made to Collector Sundargarh. Date phone to kebe apon se respond.
In other case, they are common case. In other case, they are.
ଆପଣଙ୍କ ଏଇ କେସ୍ ର ଗୋଟେ ଚିଠି ରହିଥିବ ତ ପୁଣି ଆପଣ କହୁଛନ୍ତି ନା 29/1/2025, but no response has been received. List this matter. We are listing it on 7th. Either you obtain or will ensure the personal appearance. The Land Council for the state, in view of the submission made, is this matter in the week commencing from 7th April 2025. It is made clear that if the Land Council for the state fails to get the instruction from the Collector Sundargarh, the court would be constrained to ensure the appearance of the Collector Sundargarh to virtual mode. To know the status of representation filed by the petitioner under Annexure 8, free copy of the order be handed over to the Land Council for the state. List this matter along with so and so data. The
rest of the matters, I think they have rejected the representation. Your Lordship was pleased.
No, this is just to come along with. We are passing this order in the first one. 78 we are passing this order.
78 we have already received the parawise.
They have, yes, that's the point.
In 78 we have received the parawise.
Have you ascertained about the status of representation?
That has rejected.
So why are you not telling that? Why did you pass this order?
No,
this case, 78 they have provided the parawise comments.
I'm 78 order daktulu.
No, seta thila.
99 kon.
Sorry, they are wrong file. 78 parawise comment हुआ है.
You have already received.
78 representation reject ହେଇଛି.
Communication ହେଇଛି. Mr. Rath, your client has received the rejection. You are not
rejection kon manu mana kar dele tanku janaileନି ଆପଣ ପାଇଁ rejection order ନାହିଁ.
Parawise
reason ଟା ଦେବେ ତ?
You have a copy of the rejection order along with the parawise comment.
Please verify it. Why are you?
That is not
they are entitled to know the fate of their representation. Let me. The order stand for 7 तारीख
Can I say about the rest of the matters?
This should just come along with it.
Because
7.
If you want, you may take steps for this amendment if you so.
No, they have to be communicated. They have to decide why.
ଆପଣ କହୁଛନ୍ତି ଏଟା ରିଜେକ୍ଟ ହେଇଛି ବୋଲି କହିଲେ ନା
rest of the matters
Oh,
we
sir.
challenge the rejection order itself.
Oh.
Right? And they have been noticed.
So let this matter come so that these are all identical matter, na?
Right.
Yeah, so it will be hard together.
Great.
Yeah.
Great. But can I submit one more statement?
Yeah.
In fact, there are other matters, 4 to 5 matters.
Please give it.
I'll give it. That's what I'm
Mr.
seeking.
Cross plans in advocate submit that there are identical matters pending before this court. Let Mr. Roth furnish a list of such matters so that it can be also listed along with these matters on 7th of April 2025. You give the list.
Great.
Item 7.
Please, Your Lordship. Item 7, 8, 9, 10, my lord. On behalf of the government, I pray for an adjournment.
What time you want?
2 weeks.
4 weeks.
2 weeks.
2 weeks. What is your name?
M.K.Mishra.
M.K. Vishwa.
My lord.
You have got no power in this case.
On behalf of Gopavandhu Mishra.
Item number 7,
8, 9, 10.
9 and 10. You are the associate of Gopavandhu Mishra.
No.
Give your name. Mr. Swanso appearing for Mr. Gopavandhu Mishra. 6 for an adjournment for 2 weeks. Place this matter in the week commencing from 21st April 2025. Same order in the other 3 matters, 8, 9 and 10.
Item 11.
Yes.
The last petition has directed the railway to
Please be louder.
The last state my lord has directed the railways to take instruction that issue relates to my land has been acquired by the railways, but our copy and the person who will be the arbitrator has not
We
been-
pass the order like this.
Yes.
The Union of India seeks for some time to produce the copy of the award of the compensation. So also the notification issued by the central government, if any, appointing arbitrator in consonance with Rule 3 of 2016 rules. So what is your instruction?
So far as the award of compensation is concerned, I have sought the copy. And appointment for arbitrator is still pending before the opposite part number 1.
Just a minute.
Page 19.
Wait. They reportedly filed with the prayer for direction to the opposite party member to provide a copy of the award of the compensation along with the rate and valuation of the land and price of the petition acquired by the reviewers determined under section 1 correspond to the notification and further to provide details of the arbitrator appointed by the central government provision of enabling the petition to improve the arbitration. Course of argument and conflict with the place to control the amount determined by the contempt of the which is not acceptable to either of the parties. The amounts on an application either by the party will be determined by the arbitrator to be appointed by the central government. Appointment of the arbitrator will be by central government by notification, and it will be an officer in the rank of a gazetted officer of the state government for the purpose of so on and so on. So what you have produced today?
Yeah, enclosure 1 is the award of compensation.
Acha.
Enclosure 2 is the letter opposite party number 2 to 1 to appoint the arbitrator as collector to appoint the arbitrator.
So give
That
him
is
a copy. This document which you are filing today.
In shape of a memo, have you soft copy?
Yes, madam.
You have received.
Yes, copy.
We'll go through it and see that. Okay. Who is that arbitrator?
Page 19.
Page 19, right.
Page 19.
Madam, there in page 19, they are saying it's an internal communication proposing collector to be appointed as arbitrator. So this letter is pending.
It is requested to take necessary steps for appointment of the arbitrator for the purpose who shall exercise the powers conferred and perform the duties so and so. Nomination of the arbitrator. This has been just nominated.
Number 2, my lord. We are
For
considering
approval of the arbitrator, the concerned state authority may be consulted in advance. So what final decision has been taken on this?
Not taken.
This is the letter dated 7/10/20.
This is pending, my lord.
Then they cannot, unless you, with the approval of the state, you appoint somebody as the arbitrator, and that to be by notification also. Then how can they file that application under section 20F6 if they are dissatisfied with the quantum of compensation? So this has been this letter is addressed to Chief Engineer, SC Railways,
two projects mentioned. We
So-
are concerned with project number 2, my lord. Projected serial number 2 only.
এই যে ডিএম কালেক্টর সুন্দরগড় লেখা আছে, so let that the chief engineer file an affidavit what he has done after receiving this letter from the deputy CE oblique CONJ so and so in pursuance of the order dated 13/2/2025, the learning council for the opposite party filed the copy of the award. So also the copy of the letters for appointment of arbitrator. The documents with the memo are taken on record. Copy of the same has already been handed over to the learning council for the petitioner. On perusal of the letter dated 7/10/2023 issued by DY.Deputy C.E oblique CON oblique JSG, AC Railway Jharsuguda, addressed to the Chief Engineer (CON2 AC Railway Garden Ridge, Kolkata. It appears that DM oblique Collector Sundargarh has been nominated to act as arbitrator for Borapalli loading valve at Usara, Sundargarh project in the revenue district of Sundargarh. However, it is further mentioned in the said letter that for approval of the arbitrator, the concerned state authority may be consulted in advance. When we put a pertinent question to the learning council for the opposite parties that what follow-up action has been taken by the chief engineer CON2 AC Railway Garden Ridge, Kolkata after receiving the aforesaid letter dated 7/10/2023. She submits that the nomination of DM Public Collector Sundargarh as the arbitrator has not yet been finalized. Let the Chief Engineer CON to SC Railway Garden Reach, Kolkata, file an affidavit as to what follow action he has taken after receipt of the letter dated 7/10/2023. Put up this matter in the week commencing from 15th April 2025.
Item 12.
May I please? There
Has been, kindly see the prayer.
Hmm.
Kindly see the prayer. Page 30.
Was the order dated 21/11/24 passed by the London Senior Civil Judge Jharsuguda in execution case number so and so under annexure 9.
The writ application has been filed regarding wrong calculation by the learned court below. The writ petition may not be the right forum.
writ petition is the right forum. In earlier cases, a lordship has issued notice and stayed the proceedings also. In earlier cases, a lordship had issued notice and stayed the proceedings also.
Just a minute.
In similar cases,
just a minute.
My lords.
Let us see that order. What has been held here?
Earlier.
No. The EE order.
Yes, Lord.
Please come to that.
My lord.
21/11/2024.
Page 45.
Yeah.
Annexure 9.
No, come to part 36. It will be all. Yeah.
Page 48.
46 question. The page of the order.
The order arises of a calculation sheet submitted by the JDR number 2 MCL on dated 15/1/2008 along with the claim of the decree holder for compensation amount by calculation sheet dated 15/1/2008 as per the decree dated 6/5/1995 of the Court of Civil Judge Senior Division, Sambalpur. The brief facts of the case is that the land of original claimant decree holder named Faiz Muhammad of village Lajpura, POPS, Prajrajnagar, district Jharsuguda, pertaining to Khata number 382 of village Lajpura having an area of acre 0.272 decimal was acquired for the coal mines by the state Permanent Coal Mills Limited in pursuant to the notification under Section 4(1) of the LA Act 1894. Compensation of rupees 7,627.93 has been awarded by the LA Jharsuguda for the acquired land, and the original claimant has received the said compensation awarded under protest and paid for enhancement of the compensation, and to refer the matter to the civil court under Section 18 of the LA Act 1894 for proper assessment of the market value of the land and enhancement of compensation. As a result of which, the said matter was referred to the Court of London Civil Judge Senior Division, Sambalpur, with reference to under Section 18 of the LA Act 1894. In the said reference, in order to prove the case of the claimant, examined one number of witnesses on his behalf and exhibited two documents marked as Exhibit 1 and Exhibit 2 on his behalf. The OPs exhibited one number of documents marked as Exhibit A. On considering the material available, after taking evidence both oral and documentary, the referral court held that the petitioner is entitled to receive compensation at the rate of 80,000 per along with solatium at the rate of 30%, additional compensation at the rate of 12%, and interest at the rate of 9% per annum from the date of taking possession till the final payment are made, and failing to pay the amount within 1 year from the date of the said order, interest at the rate of 15% per annum is payable till realization. Hence, after considering all the contention of the parties, after going through the case record and the above mentioned calculation sheet submitted by the DHRs and JDR number 2, and keeping in view the principles held by the Honorable Supreme Court of India in case of Sundar versus Union of India reported in 2001, bracket 2 LAC page so and so, and Chairman Navally Lignite Corporation Limited versus C. Govind Padyachi and another reported in so and so, the following calculation is arrived by this court, which is
come to the next in view of next page. In view of the judgment.
In view of the judgment passed in LA case, case number 37 of 1988 by the Court of Civil Justice Senior Division, Sambalpur, by judgment dated 6/5/1995, the calculation is made by the JDR number 2, Chief General Manager Village Bajrajnagar, is liable to pay an amount of rupees 1,94,695 to the present DHR as a total amount of compensation. Hence, the JDR2 is hereby directed to deposit an amount of rupees 1,94,695 in favor of the decree holder before this court within 2 months positively, failing which JDR2 will be liable to pay interest at the rate of 15% per annum upon 1,94,695 thereafter for delay till payment.
Yes, so what is the illegality in this order?
My lordship may see the calculation. Page 48. Now the land value is 80,000. So land value 80,000 per acre into the amount is in calculated 21,760. That is the land value. Second is 30% solation, that is 6,528. Third is additional interest 9,701. The total amount comes to 37,989 less the amount already paid. Now the excess compensation amount is 30,361.
Yes.
And I am to pay interest on the first year at the rate of 9% on 30,000 and 15% till the payment is made on 30,000 itself. Now lordship may see interest 1 year from 87 to 88, 2,732 has been calculated. Thereafter interest from
এটা ঠিক আছে তো
আগে ঠিক আছে তারপরে 88 to 99 ক্যালকুলেট করদেলে 74,745 চালি আসিলা তার ভিতরে when we came to High Court challenging the land acquisition order, miscase order, Honorable High Court had directed us to deposit 7,000 rupees. That has been deducted. And the value has come to 72,555. And now on this amount, they have calculated interest on 15%. This 70,745 includes interest of 15%. The interest should be calculated on the excess amount, that is 30,361.
No, till it is paid will be wording
again.
You 15% wrong.
Again.
ଆପଣ ସେ ଯୋଉ 72,000 ଟଙ୍କାଟା ଯଦି 1999 ମସିହାରେ ତାଙ୍କୁ ପେମେଣ୍ଟ କରିଦେଇଥାନ୍ତେ ମ୍ୟାଟର ଇଏ ହେଇଥାନ୍ତା, କିନ୍ତୁ ଆପଣ ପେମେଣ୍ଟ କଲେନି, ତେଣୁ ଯୋଉ 15% ଇଏଟାକୁ ସେଟା କଣ୍ଟିନ୍ୟୁ କରିବ ନା ନାଇଁ?
ଆଜ୍ଞା କରିବ, ମୁଁ ସେଟା ପେମେଣ୍ଟ କରିଦେଇଛି. ଲର୍ଡସିପ will for a moment come to
I think that we passed
yes, your lordship has passed various orders in this. जो excess जो interest है, it is 72,000 अच्छी ना, this includes interest. So now interest is in calculated upon interest.
You are right.
We should
carry that order. Please show us one order.
So that changes kariya padibo. Earlier, lordship had passed these orders.
No, she is raising the point regarding maintainability to the repression against such kind of order passed by the executing court. Whether a writ is maintainable.
Writ is lordship had passed.
যদি ভুলে ওটা পাস করছে সেটা দেখেবে না কোন রিট মেইনটেনেবল না আগে স্যাটিসফাই করুন উথরে গোটে যে সেথরে যে স্টেট কাউন্সিল যে থিবে সে অপোজ কর নথিবে সে রেজ ইস্যুটা রেজ কর
নোটিস ইস্যু হইছি খালি
নোটিস ইস্যু
ସେଇଥିରେ ହେଇଛି ମାନେ ଏଇଥିରେ ହବ ବାଧ୍ୟ. You have to satisfy this court that writ is maintainable.
Against the order passed by the executing court, writ is maintainable. No other quorum is available against that.
Yes, madam.
CMP is the right forum according to CMP is the right forum. This is the order passed.
Civil miscellaneous petition.
Writ is maintainable against the order.
Under Article 227, CMP would be maintained.
Order. Any order passed by the civil court?
Yes.
In execution case, an order has been passed.
Yes.
So against he is dissatisfied with that.
Yes.
So if he wants to challenge, you want to say that the nomenclature is only to be different.
CMP will not be there.
Interlocutory order जोड़ा civil court pass करछंती.
Yes, sir.
This is already disposed of finally.
Finally disposed.
It's not an interlocutory order. The execution proceeding has been disposed of and this order has been passed. Final order has been.
It's a final order. There is tribunal. While the civil court is deciding on rejection case, there is tribunal.
Referral court.
Yes. So সেটা রিট হয় CMP হয়. Civil court
No, এটা execution order.
Tribunal.
But execution file is arising out of that reference.
Of the reference, LMS case.
Right, so that is been finalized.
Right.
Question hochi tara jodi anna kichi alternative remedy achi, the writ would not be maintainable, that's it. But he says that just the nomenclature is to be changed. So that is to be called CMP na
CMP.
But whether
I'll check, Your Lordship.
check it.
I'll check.
We can take up this matter on Monday, Tuesday, sorry, Wednesday.
Or else Your
Upon
Lordship,
video देखी दियो
Mal-
ये जो
as in past
nomenclature
other
टा
cases.
particularly कहउछंती
I'll check
बोला
it.
एटा ई against ए nomenclature टा
I'll check it.
है ना though the अच्छा order टा लिखी देना ठीक है सुविधा देखो this writ petition has been filed by the petitioner General Manager Ivy Valley Area Mahanadi Coalfields challenging the order dated 21/11/2024 passed by the London Senior Civil Judge Harsuda in execution case number 31/94 of 1997-2004 by Annexure 9. The London Counsel for the petitioner submits that in similar matter, this court in that is in WPC number 30441 of 2024, this court has been pleased to issue notice to the opposite party on the question of admission. However, the London Counsel for the state submits that the nomenclature might be changed to CMP. Na kaun kହୁचंदी? CMP.
I'll check whether any other remedy is available to the petition.
Ajay, let's submit that she may be given some time till next week to verify whether this order under Annexure 9 can be challenged before any forum, or there is any alternative remedy available. There is any alternative remedy available to challenge the order passed under Annexure 9. Put up this matter. 2 तारीख रखिबा ना 7 तारीख को नहीं जुआ. You examine or student? 7th of April 2026. Adil thibo sei CNP 2 order pe
I'll examine it. Civil suit ro jo interim order gura ko.
This is it appears that is a finally disposed of.
Because in this case, what had happened when we gave our calculations, the
No. The issue to be examined point that the final order passed in an execution proceeding by civil court. What is the remedy?
I'll apprise the lordship on the next.
Agreed by such order.
କାରଣ ଯେମିତି interlocutory order ଗୁଡାକରେ revision maintainable ନାହିଁ ତ final order ହେଇଗଲା revision maintainable. So ସେଇ type ର ଅଛି interlocutory order ହେଲେ କଣ ତମେ କରିବ କୋଉ ତାର nomenclature କଣ. But
final order against the
it appears that the execution proceeding has been disposed of finally.
It's disposed of.
So
I'll apprise the lordship on the next.
Yes.
Item 13.
Yes, non-payment of compensation enforcement reward annexure 1. In similar cases, your sister annexure 2 directed the government to sanction and pay. Our matter. If annexure 2 page 16.
Is it a executing court for implementation of order passed by the London civil judge?
Here the award
You file execution case.
Award has not been challenged, and this is now admissible to use.
So what? You file execution.
And
Why read court shall give a direction for implementation of the order passed by the referral court?
In some cases, you should dispose, in some cases, you should directed to obtain instruction. Yesterday, also some matters are there. You should adjourn the matter for to obtain instruction.
ମାନେ payment ହେଲାଣି କି ନାହିଁ? ସେଇଟା
This kind of writ petition amounts to docket explosion, unnecessarily burdening this court with this kind of writ petitions. ସୁବିଧା ଆପଣଙ୍କ ପାଖକୁ ଆସିଲେ ଆପଣ ଏଇଠି କରୁଛନ୍ତି ପ୍ରାକ୍ଟିସ କୋର୍ଟ ଆଡଭାଇସ କରିଦେଲେ ନହେଲେ କ୍ଲାଏଣ୍ଟ ପଳେଇବ ସିଆଡେ କେବେ କାର ଆୱାର୍ଡ ହେଲାଣି 18 ର ଏକ୍ଜିକ୍ୟୁସନ ନ କରିକି ଏଠି ପଳେଇ ଆସିଲେ ରିଟ୍ ରେ କଣ କରୁଥିଲେ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଦରକାର ନଥିଲା
ଲେଖିଛନ୍ତି ଆପଣ କୌଣସି ପାରାଗ୍ରାଫ ରେ ଯେ ଏ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ ହେଇନି ବୋଲି ଚ୍ୟାଲେଞ୍ଜ ହେଇଥିବ କି ଜାଣି
ଏଜୁକେସନ ଲିମିଟେସନ କେତେ ଅଛି ଯାଆନ୍ତୁ ତାହେଲେ ଅଛି ଯଦି ଭିଡିଓ କରନ୍ତୁ ଏଜୁକେସନ ଫାଇଲ କରନ୍ତୁ କୋଉଠି ସିମିଲାର କେସ୍ ଦେଖେଇଲି
କାଲି ଥିଲା ଆଜି ମୁଁ ଦେଇଛି annexure 2 years
18 ର
annexure 2 years para 4 ଆଜ୍ଞା ସେ instruction is Lordship, no, that is the longest chapter we see.
ଚ୍ୟାଲେଞ୍ଜ କଲେନି 2018 ରୁ ତାହେଲେ ଆପଣ ଚୁପଚାପ ବସିଗଲେ
annexure 4 years
ଭେରି କ୍ଲିୟର ଅଛି ଆପଣଙ୍କ ପେପର
ସବୁ ଯାକ ବେନିଫିସିଆରୀ ବି
ପାର୍ଟି ନାହାନ୍ତି
annexure 4 years ଏଇ para 4 years କମ
ନାଇଁ ଖାଲି ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇ ହବ ଯେ ମାନେ ଏଇ ଅର୍ଡର ଅନୁଯାୟୀ
पेमेंट ହେଇଛି କି ନାହିଁ
पेमेंट ହେଇଛି ନା ନାହିଁ we are not telling you that ଏଇ ଯୋଉ ପେମେଣ୍ଟ ଟା କେବଳ ପିଟିସନର କୁ ହବ କାରଣ ଅର୍ଡରରେ
appeal ହେଇଛି କି ନାହିଁ ଏଇ କୋର୍ଟ ରେ
whether it has been challenged or not number one if not challenged whether the payment has been made in pursuance of the order or not that's two things you are this writ petition has been filed by petitioner Krishna Maji challenging with a prayer for a direction to the opposite party to sanction and disburse the compensation amount in favor of the petitioner's family pursuant to the order date ke
20th March 2018
order dated judgment and order dated for 20th March 2018 passed by the Learning Civil Judge Senior Division Bhavani Patna in LAR number 168 of 2017. Within a stipulated time. The Land Council for the state seeks some time to obtain instruction as to whether the order under judgment and order under annexure 1 has been challenged in any higher forum or not, and if not, whether any steps have been taken for payment of compensation in terms of the aforesaid order dated 23/2018. Put up this matter. Kebe rakhiyo, madam?
2 weeks after.
2 weeks after. 21st of April 2025.
Accept order.
Attention for the raise is
same
no objection
there is no other impediment kori
most likely would instruction nahi gayi with other knows that with a challenge ki
order number 1
next date yes similar matter eguda so
up to 19
13 or 2 up to 19
गोटा ऑर्डर हेला संग संग आप फाइल हेला
more than 500 pieces already filed
case number
केतला फाइल को जन
no माने in general
yes next
item 20
My lord.
Section 64 may be the remedy.
Chal.
Yeah, our address is dissatisfied means section 64 may be the remedy.
Set aside the order dated 2/1/25 and then further direct the opposite to pay compensation acquiring the land transfer. Two order to pass karibe annex one.
Our
Benchmark valuation and actual for
So annexure.
for the benchmark valuation now.
That means you are dissatisfied that you want that higher compensation to be made.
My lord.
So the provision is rightly pointing out.
My lord.
64 is there.
My lord.
So approach the concerned authority. Representation ne काम होबनी आपनको लिखंदु. This writ petition has been filed by the petitioner Virendra Mahapatra to set aside the order dated 2/1 order notice written. Notice oblique order, notice oblique order dated 2/1/2025. Issued by zone officer -com LA collector, तले कौन लिखा है SIP ना GIP कौन लिखा है
SIP बारीपदा
SIP S.I.P, बारीपदा zone. अच्छा এটা নোটিশ ডেট भी देगा कौन कोई तो ना নোটিশ ডেটটা উপরে আছে না এই ধরো ডেটটা আছে 2/1/2025 কিন্তু ইস্যু হলো এটা 17/1/2025 সাইন করছেন 2/1/25. All right. From the which a further prayer to direct the opposite parties to pay compensation to the petitioner for acquiring his land on the basis of valuation prevailed as on date. From the averments taken in the writ petition, it appears that the petitioner, say 64 language study.
File protest petition, there's a period of limitation, 60 plus 60. Limitation is 60 days. And if there is a delay, at best, further 60-day delay can be condoned. So it should be at the earliest. File protest petition, receive the compensation under protest, and
they have already received the compensation.
So file protest petition.
That if the that he is not satisfied with the amount of compensation which has been ordered to be paid, and he claims higher compensation basing on the benchmark valuation dated 31/2025 under Annexure 5. Though a representation has been filed in that respect under Annexure 5, but the Learning Council for the petitioner submits that since under Section 64 of 2013 Act, he can approach the collector for such purpose for making reference to the authority in accordance with law, for adjudicating the amount of compensation, he may be permitted to withdraw this writ petition to approach the appropriate authority. Accordingly, the writ petition is disposed of. Yes, we're just coming with it.
Item 21.
Say
Compensation in lieu of land acquisition. Annexure 6 Lordship of Lands. Similar matter has been disposed of by this honorable court. In that light, your Lordship may dispose of.
What is your prayer first, Your
To sanction and dispose the compensation amount in lieu of land acquisition by the opposite party number 4 and 5.
Where is the document to show that your land has been acquired?
Annexure there were annexure 4, page 15 and
No, ROR can jona padiyo mo anu apno land acquire heyi. Where is the notification?
Notification annexure 1, page 12.
नंबर टा कहीं आपण जो के पट्टा आपण के जो ए प्लॉट ए खाता मौजा या एटा एक्वायर करा गला एटा तो खाली गोटे नोटिस टा आपण देले जनरल नोटिस
Notice annexure 1 ROR melody page 1 melody Mauja Asulpur Hal Khata number 99 plot number 66 area 20 decibel.
कोटा प्लेस को
Para 1 of the rejection. Page 3.
आपण जो लैंड एक्विजिशन हुए जो बाहर गुडाए नंबर सब बाहर कार प्लॉट केते नंबर
से सब किछि देई ना आज्ञा सिमिलर मैटर लॉर्डशिप
पेपर बाहर सर लीडिंग न्यूज़ पेपर
no
so बाहर
This is under the old act.
Only सर्वसाधारण notice is there. Similar matter recently lordship disposed of. Same mauja same area same
Section 11 ହେଇଛିନା ନାହିଁ ବି କିଛି information
ଘୋଷଣା ହେଲା
recently lordship disposed of by this bench my lord lordship have a glance.
କଣ ଆଗ ବୁଝୁ ଜିନିଷଟା କାଲି dispose of କଣ
12
ଗୋଟେ
13
ନୋଟିସ ଟା ହେଲା ଆପଣଙ୍କର ଏଇଟା ହଉଛି ଆପଣଙ୍କର
4-1 notification yes
ତାପରେ କଣ ହେଲା
ତାପରେ କିଛି ଦେଇନା କିଛି ନାହିଁ ଜାଗା ନେଇ ଯାଇଛନ୍ତି ଆଉ କିଛି
ନେଇଗଲେ
ନେଇଯିବେ କେମିତି ଏମିତି କିଛି ଜାଗା ନେଇ
ତାପରେ no notice has been served upon us nothing done
abnormal delay ଟା କଣ annexure 2 ଟା
delay in land acquisition
देखिए ये लैंड अभी स्टार्ट करो
Union Management Planning Land of Property ଏଟା 16 ର ଚିଠି Annexure 2 ଟା is of the year 2016 when the executive engineer of the concerned division has mentioned that though the entire amount has been deposited with solacem and interest, only 32.87 acres land has been handed over to the Water Resources Department. It was written to the collector judge.
और preliminary notification हला परे जो objection अच्छी अन्य जो procedure कराई थी तापरे फाइनली 11 रे रहउची जोटा इंक्वायरी और अवार्ड ऑफ द कलेक्टर ये सब रहिची तणु ये तो गोटे एस्पेक्ट द्वितीय एस्पेक्ट होची किसी जणा पडुनी आपनकर ए नोटिस टारू आपनको जमीटा आपन केमती कोन कंपेंसेशन केमती दिया हो
lordship similar method has been disposed of by this court in WPC number
कोन हमें करछु कोन जो सिमिलर सिमिलर कोन
lordship recently lordship disposed of by this bench my
कोन कराई ऑर्डर कोन
direction will be given to collector to inquire into the matter if land has been acquired then compensation may be given
land compensation got lost. Environment was approved by
fact different थी
यार होगा fact आपनकर ये
ସେଥିରେ already deposit ହେଇଥିଲା instruction ଆଣିକି ଆମେ କହିଥିଲୁ
नहीं एथरे भी डिपॉजिट executive engineer लिखिचंती the entire amount has been deposited with solacem and interest but
so page 22
delay
it is page 22 ରେ specific contention thila the learned advocate additional government advocate submitted the compensation amount has already been deposited with the opposite party and the same shall be disbursed in the period
been deposited but not disbursed my lord
एथरे देखंतु annexure 2 टा देखंतु See Annexure 2.
Yes. It is there.
The money was deposited with the collector.
The only question, the pertinent question is whether the particular
Total project, for the project, 94.19 acres of land were required to be acquired. For that, the land acquisition cost arising of so and so, along with solution so and so, has been deposited.
Yes, sir.
The above amount has been deposited with the Tahsildar cum land acquisition officer very between so and so 2011 ଭିତରେ ହେଲାଣି।
ଏଇଟା 16 ନୋଟିସ୍
ନା ନା ଏଇଟା 16 ସେ କହୁଛନ୍ତି ଆଉ ଦିଅନ୍ତୁ ଆମେ 11-13 ଭିତରେ ସବୁ ଟଙ୍କା ଡିପୋଜିଟ୍ କରିଦେଲୁନି। Hide 7 numbers of checks.
Yes, sir.
But till today only 1 crore 12 lakhs so and so has been disbursed, and only 32.87 acres land has been handed over to the
then you obtain instruction in the matter.
so that it can be disposed of on the record.
This petition has been filed by the petitioner Brahmananda Mahanti with a prayer for sanction and disbursement of the compensation as per the policy of the government by the Annexure 2 relating to Khata number 99, plot number 66, area approximation 20 decimal in Moja, Asalpur, Tahsil Bari in the district of Jashpur. The Land Council for the petitioner submits that the petitioner is the son of late Balaram Mahanti, in whose name the land appertaining to Mauja, paragraph 1, so has been recorded, and the same has been acquired by the state for flood protection of Brahmani-Kelua-Virupa Dob of Brahmani system. He has placed the notification issued under Section 4 of the Land Acquisition Act under Annexure 1 and further submits that Annexure 2, which is the later dated 8/1/2016, would indicate that land acquisition cost along with Solasium, etc., have been deposited with the Tahsildar cum land acquisition officer Bari. However, the petitioner has not yet received any compensation. The record of right has been annexed to the writ petition as Annexure 4 it appears that the other recorded tenants on or their legal heirs have been not arrayed as parties in this writ petition. Be that as it may, let the Land Council for the state obtain instruction as to whether any land of late Balaram Mahanti of Asalpur in the district of Jashpur has been acquired for the aforesaid project or not, comma, if any compensation has been paid to anyone for such acquisition, and if not, the reason for delay in payment of compensation amount. Please, this matter, केबे रखियो कुहंतु?
4 weeks.
4 weeks. Matter be listed in the second week of May.
बैंक रखिले 7% भी पाई नथिबे 15% पाइबे जो देई नथिबे
Item 22.
Because these are not the time. Yes, 22. One is there. Password for them.
Item 23.
Yeah, my application under section 28A is pending. At annex of 2, page 27. Next up is the order you are directed, without going into merit of the case, directed the land action officer to dispose of the 28 application. In the event that will be allowed, that's something.
Similar prayer is there here.
Yes.
28 application.
And next up 3.
Project same.
Same.
Lawyer Indra Irrigation
Yes.
Project
Lawyer,
Career.
Yes. Same.
Mr. Nayak.
Yeah.
Same project.
Same project. Not but that is the
Correct.
Hmm?
One.
Referring to annexure 1, annexure 2 has been filed. Annexure 1 is the 18. After disposal of the 18 and the 28 application filed.
I think the relation that is the for petition 1, 2, and 3.
No, you mean to say that some persons have been left out? That is your.
No.
They are saying that they are level. And there is Samsundar Maji, Dambaldhar Maji, Rameshwar Maji, and the Pitambara Maji and Nilavati Maji. They are the applicant in the LR case.
Who is this petitioner?
Now in the
Balmak Maji.
Who is he? How he is related?
Madam, here what happened? When the land acquisition proceeding is going on, the persons who will file protest petition, he is entitled to file 18 application. And the person who will not accept the award without protest.
So you are not one of the petitioners?
No.
You filed the objection.
Yeah, I am referring to this judgment. I am claiming higher compensation under section 28A of the Land Acquisition Act.
Is the compensation that is
not required.
They are not disclosed that what is the compensation they are
not required.
getting.
You still have a glance. You see, LR 21 of
just a minute. The order was passed where the petitioners are Shamo, then Dambaru, Shamo mane Moriola, there are legal representatives Sasiole, Dambaldhar Rameshwar, then Pita and Nilavati. They are the petitioners, and the reference was answered, and the order was passed. Yes. What amount is to be paid?
Yes, that's it.
That is in the order portion. Yes, page number 24, running page. The reference is allowed on contest against the opposite party, but without any cost. The recorded tenant is entitled to get compensation of rupees so and so for a car. Hala, ए जिनसे होला कि कौन कहते interest पाइबे कौन भी उड़ा सब दिया है.
Yes.
So then this application petition was filed under it 28 land acquisition of. Yes, sir. Okay.
I'm placing one.
Wait. Redetermination of the amount of compensation on the basis of order of the court. where in an award under this act, the court allows to the applicant any amount of compensation in excess of the amount awarded by the collector under section 11, the person interested in all the other land covered by the same notification under section 4, subsection 1, or who are also aggrieved by the award of the collector may, notwithstanding that they had not made any application to the collector under section 18, by written application to the collector within 3 months from the date of the award of the court, require that the amount of compensation payable to them be redetermined on the basis of the amount of compensation awarded by the court, provided that in computing the period of 3 months within which an application to the collector shall be made under this subsection, the day on which the award was pronounced and the time requisite for obtaining the copy of the award shall be excluded.
Yes.
The collector shall, on receipt of an application under so and so, conduct an inquiry after giving notice to all the parties interested, giving them reasonable opportunity of doing and make an award transfer. Any person who has not accepted the award may, by written application to the collector, require the matter be referred by the collector for determination of the court under section so and so. So this period is for 3 months.
Yes, ma'am.
So whether that application was made during that period.
Yes, ma'am. That's annexure 1, your counsel, page 8.
The order dated, award is dated
18 April 2024.
4/2024.
And
28 application upon ke bedale.
You have to come the annexure 2.
17 May 2024. Yes, sir, it is within the time. So,
and annexure 3 is the similar order.
Correct
for the with your permissions.
ଆମେ ସେଇ କଥା ମଧ୍ୟ ନେଇଛୁ ସେଇ ଯୋଉ ଅର୍ଡର ଲେଖା ହେଇଛି within a period of 3 months. ହଁ କେସ୍ ନମ୍ବର ଅଲଗା ହବ ଦେଇ ଦେଇଛନ୍ତି କରେକ୍ସନ କରି yes same ତ 23 24 25 26
so would in time
otherwise you will reject the LO will reject
because there is no
legal
given them any scope to extend that period.
No cannot
3 ମାସ ଭିତରେ ଆପଣ କରିବାକୁ ପଡିବ. Yes.
Item 27.
May please, Your Lordship. Your Lordship, I'm alleging the willful disobedience of the order dated 18/9/2024 passed by this Honorable Court.
What order was passed?
The order was passed to give compensation to the petitioner with respect to the structural cost.
Come to the operative part of the order.
Page 13 here.
Yes.
In view of the letter of the collector Burger under Annexure 3 and the valuation report furnished by the executive engineer, opposite party number 5 under Annexure 4, and after hearing the learned counsel for the Union of India, we direct the NHI authorities to take immediate steps for payment of compensation to the petitioners as per the valuation report under Annexure 4 within a period of 1 month from the date of production of a certified copy of this order before taking any steps for vacating the premises. The NHI authorities shall also communicate the order to the concerned authorities for compliance.
So where have you taken the ground that you have submitted or you have produced the certified copy of the order? And on what?
Annexure 2 series, Your Lordship.
Annexure 2 series.
It's the covering letter.
अच्छा.
Along
ଗୋଟେ ମାସ ଭିତରେ କହିଥିଲା produce କରିବା ପାଇଁ.
Yes, sir.
ଆପଣ ଦେଲେ 7/10 ରେ.
Yes,
अच्छा.
sir.
Authority postal receipt ଅଛି.
Yes, sir.
କି appear କରୁଛନ୍ତି ଏଇ ଯୋଉ କି କହ 100 national highways ର ଅଛି. So notice ଯିବ ଆଦେରେ.
Yes, Your Lordship. Your Lordship, the only difficulty is, Your Lordship, in similar matters, Your Lordship had issued notice and they have filed a show cause wherein they have stated that the contender has already been relieved from the office before.
Then you got to take instruction. take instruction, who is the person?
Yes, Your Lordship.
He
The
cannot,
website shows
the person who has already retired or he has gone to another place.
Yes, Your Lordship.
So the correct person should be the contemner.
Yes, Your Lordship. So,
So if you have got no instruction till now, you can take time and ascertain the name and then just
obliged.
make an appropriate application to change the contemner's name,
Obliged.
right? This contempt petition has been filed for non-compliance of the order dated 18/9/2024, passed in WPC number 22699 of 2024. The Land Council for the petitioner submits that though the contemner's name has been mentioned to be one Sunil Kumar, who was the General Manager, Technical, National Highways Authority of India. However, she has instruction that the somebody else is now posted as a General Manager Technical, and therefore she has to obtain concrete information in that respect and file an interim application for amending the first title and for such purpose, if some other time,
2 weeks.
2 weeks time may be granted. This matter in the week coming. 21 तारीख को रख लीजिएगा.
Obliged.
This matter on 21st of April 2025.
Item 28.
Similar matter.
এটা ফার্স্ট টাইম আসছি.
Yes, Your Lordship. Both.
ইয়াদের বিষয়ে সুনীল কুমার লিখছেনদি.
Yes, Your
আচ্ছা
Lordship.
এটা সেম অর্ডার হবে. কিন্তু অর্ডার ডেটেড আর এগুলা সব চেঞ্জ হবে. তো রিট পিটিশন হ্যাঁ 21/4/2025. Yes.
Obliged, Your Lordship.
Item 29.
Yes, Mr. Behra. Yeah.
29.
29. Absolutely. First time as chief.
First.
Which is the non-compliance order dated? Representation dispose of.
Yes, as per your yes.
2/7/2024 order passed.
Yes, sir.
And it is to be disposed of within 3 months from the date of production of the certified copy of the order.
Page number 18.
Page
Page
number
number 10. Yours.
ঠিক সম্মার ଦେଇଛନ୍ତି.
Yes, sir. Page number 11.
So ଇଏ ବର୍ତ୍ତମାନ ଆଣିବ land acquisition office. এটা ତ ଷ୍ଟେଟ୍ ଏଜେନ୍ସି ଆଣୁନାହାନ୍ତି ତାଙ୍କ ରିପ୍ରେଜେଣ୍ଟେଟିଭ ଷ୍ଟାଟସ୍ ଟା କଣ ହେଲା ଡିସ୍ପୋଜ ଅଫ୍ କରିନକି କାହିଁ ପକେଇ ରଖୁଛନ୍ତି ଲେଖନ୍ତୁ. The Land Council, this contempt petition has been filed for non-compliance of the order dated 2/7/2024, passed in WPC number 15425 of 24. It appears that this court directed the opposite party number 4 to consider and dispose of the representation filed by the petitioner and to pass appropriate order as early as possible within a period of 3 months from the date of production of the certified copy of the order. The Land Council for the petitioner submits that the order was communicated. Communicated kind of
You're on page 11. Yours. You're on page 12. 11 and 12.
only 11.
Annexure 2. Your Lordship.
ଅର୍ଡର କଥା କୋଉଠି ଲେଖିଲେ?
Order କୋଉଠି ଲେଖାଯାଇଛି ମୁଁ?
ମାଇଲର ଲେଖାଇ ଧଇଥାନ ସହାୟତା ରାଶି ପାଇବେ ଉଚ୍ଚ ନ୍ୟାୟାଳୟର ଆଦେଶ WPC ନମ୍ବର
ଉଚ୍ଚ ନ୍ୟାୟାଳୟର ଆଦେଶ WPC ନମ୍ବର ଉପରେ ଲେଖିଲେ.
Alright. Has communicated the order under Annexure 2, the concerned authority
10/7
on 10/7/2024, but no action has been taken. But he has not been communicated with any decision taken on the representation. Stop. Land Council for the state seeks some time to obtain instruction relating to the status of representation. Put up this केबे रखिवा अपन टाइम नियंतु किंतु काम सर दियंतु जणी दियंतु हला communicate representation disposal करी जणी दियंतु matter be listed in the week commencing from 29th रखि दो हला you are getting 1 month time हला तो 29/4/2025
up to 33. Up to 33.
next
Up to 33.
एटा सब सही
Same.
representation
Yes,
disposal
yes.
अब देइचंदी सब माने
Same. Annex 2 year. Same date. 10/7/11 to 2024.
देखिए अन्य गुड़ा से कहते समान बिल तो रिपिटिशन ना जो ये चेंज हो नंबर गुड़ाक और डेट टाक देखिदेवे केबे डिस्पोजल डेट है so all will come on 29/4/2027 so
Like
Item 34.
In this case, both the petitioner and OP number 1 have expired. Had filed the IA for limitation, abatement, and substitution. Due to some technical errors, last occasion the Honorable Court that file fresh IAs. I want to not press the present IAs and file liberty to file fresh IAs.
fresh है फाइल करचंदी
Original.
अब कोन नॉट प्रेस करिवे कोटा कोटा नॉट प्रेस कोटा कहि दियौ नॉट प्रेस करिवे आईए नंबर
437, 438, 439,
just a minute 437 तो किछि नै 437 से नॉट प्रेस करिवे आईए देखंतु 437 of 2024 this is an application for so and so land council for the petitioner you are Mr. B Panda doesn't want to praise this interim application accordingly disposed of as not pressed आउ कोडा not press करिवे
6 टा 437 438 439
अरे धीरे धीरे जान अरे
28 29 30 24
ठीक है स्लो जान हम गोटे गोटे लिखिबो ना सेमाने पुनी डिक्टेशन नउचन सेमान लिखिबे 437 गला 438 गला तापरे
439
439 not press
तापरे 24 गला 428 429 430 तेरा 24
सब गुड़ा को कोटे कॉमन ऑर्डर करी
आगोरा 23 24 पडिछ नंबर
429 24
37 23 38 23 39
429 भी नॉट प्रेस
आया
तापर 428 नॉट प्रेस
आया
430 भी नॉट प्रेस
अच्छा छोटा
खाली लिखि देबे को आईटा कोन पे गोटे लाइन हला नॉट प्रेस हां
लिबर टू फाइल रिफ्रेश एटा उड्र नकला पण नुवा फाइल करबो
ठीक अछि एवं 90 of 22
सेटा रिव्यू करछ सेटा
रहइबो से लास्ट रहइबो 90 of 2022 टा रहइबो बाकी जेतिको आईए रहिछि खाली गोटे गोटे लाइन लिखिकिनी सब ये कर देबे नॉट प्रेस कर देबे
जोड़ा सब्स्टिट्यूशन परे सेउडा पुनी आउथरे फाइल करिवे
बाय द पिटिशन रहि था तो कोर्ट ऑब्जेक्शन करले पिटिशन रिलेटेड
in order to file the press interim application not press in order to file press interim application you line tar sabute rakhi de first so disposed of not press kariye disposed केवल शेषटा रहउछि आ आईएन नंबर 90 टा रहउछि आ सब रहउछि yes next
Item 35.
Item 35, my lords. The board trust has filed an IA 40424.
It was filed by us. Yes.
Yes, my lords. And we don't. No copy has been served on us. Let them serve a copy. Let it come up after 2 weeks.
Mr. Hari,
my clerk told that it's given. If not given today itself, we'll file.
No,
Mr. Kanun says that it has not been given.
Then I'll give another.
The is also there that it has not been served.
All right. And IA number so and so. This is an application for vacation.
4024.
Huh?
4024 of 2020.
402.
For vacation of the interim order dated 13/2/2023. The registry has pointed out that second copy of the IA has not been filed. Also, the copy has not been served on the learned counsel for the petitioner. Mr. Milan Kanbul and senior advocate also submits that no copy has been received by him or his associates. Mr. Paril and Deputy Solicitor General, they are appearing.
We will also appear for court trustees.
And also for the opposite party number WPC देखिले से post
234. 234.
234. Then all the opposite parties for
all the opposite parties.
all
Yes.
the opposite party submits that the copy of the interim application will be served by केबे लिखिवा
By today or tomorrow.
during by tomorrow लिख दो हाँ
Yes.
by tomorrow. Mr. Kanun को submit that the matter may be taken up after 2 weeks in order to enable him to file.
My there's short period after 1 week any deadline. Every reading complete, I'll serve the copy.
Yeah. So we are keeping it on 15th April. So you filed in 15th April 2025. Objection, if any, to the interim application be filed in the meantime. Right?
Okay.
Yes.
Interim orders will continue.
Interim order is here. Interim order dated so and so will continue till next day.
Mr. Kashyap is appearing with his name.
अच्छा.
Satya Sindhu Kashyap.
Mr. Kashyap का नाम होता है लिख S.S. Kashyap, Reliance Central Government Council, along with Mr. Pani को सहित matter लिख. Yes.
Senior Panel Council.
Senior Panel Council.
अच्छे तरफ में senior council.
अच्छा तो हाँ ठीक है तेरा CGC करीबे नहीं Senior Panel Council को. Yes.
Obliged.
Item 36.
36, Mr. Ravi Narayan Behra. No one is there. Password for them.
Item 37.
37 next year, sir, council.
What people?
Can be taken up next year.
Number concerned. Okay. The mention is made on behalf of the Grand Council for the senior advocate, Mr. D.P. Nanda, to take up this matter next week. Next.
Secondary interim order may kindly continue till next date. Sub item
Swanso 6 for an adjournment till next week कर दें तो हाँ interim order देख देवे dated Swanso interim order to continue हाँ till next week.
Item 38.
The sub item will interim order the sub item.
हाँ इटा तो WPC number 4781 of 23 रे देख check कर देवे interim order कौन अच्छी कोई है इसे उधर continue करो next week पर.
My lord, I am for the petition. In this case, during pendency of the writ petition, proponent of opposite party has been died. He is survived by his nephew, whose name and particulars has been mentioned clearly in the IR number 2509 of 25. And accordingly, he may be substituted in place of the proponent of opposite party number 5. And accordingly, registry may be directed to main necessary corresponding the first paper.
Wait. Your IA has come for legal heir of pro forma opposite party number 5.
My lord.
With that opposite party number 5, Doitari Naik. What is the that legal heir certificate to show that you are the who is to be substituted?
His grandson, my lord.
Thank you.
His wife and his son has been died. He is survived by the nephew only.
Ground nation. Is it your case that the person that is Hemanta Naik is the only person left out to be substituted, others are not?
only surveying legal heir of the proper opponent or 5 minor.
So you take instruction on this interim application, right? IN number 2509 of 2025. This is an application for substitution of legal heirs of pro forma opposite party number 5. ना लिखी दियंतु Doitari Naik, who stated to have expired on केवे ଦେଇଛନ୍ତି ମଲେ କେବେ
डेट मारो ସେ କହିପାରିଲେନି ତାଙ୍କ legal heir ସେ କିଛି କହିପାରିଲେନି illiterate person they are living remote part of the
death certificate ନାହିଁ
ସେମାନେ ତା କିଛି ଦେଇପାରିଲେନି ତାଙ୍କ ଘରକୁ ଯାଇଥିଲୁ ଆମେ
କୋଉଠି ଲେଖିଛନ୍ତି ମରିଗଲା ବେଳେ ଖାଲି died
during pendence of the writ petition he has been died particular date ଟା petition କୁ ଜଣା ନାହିଁ petition ତା ଘରକୁ ଯାଇଥିଲା କିନ୍ତୁ କିଛି ଡାଟା ପାଇଲାନି ଖାଲି ମରିଯାଇଛି ବୋଲି କହିଲା ତା grandson survey କରୁଛି ଆଉ ତାର ପୁଅ ସ୍ତ୍ରୀ ସବୁ
died and it is further stated that the wife sons of pro forma opposite party number 5 also died and only Hemanta Naik with the grandson.
Yes.
Grandson though?
My lord. He is only serving here.
He is surviving. And therefore, he may be allowed to be substituted against the pro forma opposite party number 5. Learning Council for the state has received the copy of the interim application and seeks some time to obtain instruction.
Other this petition with this petition.
अच्छा ये notice कर दे रही जीवन वाले issue notice कर दियो तो Learning Council for the state accepts notice on behalf of किए थिवे कौन थिवे 1 2 3 पाए so far as 4 is concerned notice issue करता है
अगर से पूरी notice पाइसान किंतु से चाहूँ नहीं थे contest करे पेंगी appear होंगे
एंती किम जाने
let
the notice be made sufficient if she does not appear no. Cannot leave like that person. Yes, file your requisites for issuance of notice on opposite party number 4. So matter will be listed on such and such date. You file the requisites within a week. And extra copy also on the Learning Council for the state. Extra copy on state. Now, same order in
other two matters.
Next.
May item 36.
Sorry, your list. You have to go to the matter.
Item 39.
Filed in IA for amendment of the prayer.
What amendment you will say? Who has filed the writ petition? Chunnu Behra. And copy has been served on the. Who is appearing for the other side?
For the petitioner NR Rausre. Please come.
ଆପଣ ପୁରା ହଉଛନ୍ତି ଅପୋଜିଟ ପାର୍ଟି ପାଇଁ amendment କାହା ପାଇଁ କିଏ ଫାଇଲ କରୁଛି
amendment has been filed by the petitioner
ଆପଣ କିଛି ଆପତ୍ତି ଅଛି କି
ନା
କଣ amendment
ଖାଲି କହିଦିଅନ୍ତୁ ଯେ tribunal ର order ଟା pass ହଉ and the death cum financial benefit be released
ଏହାକୁ ଖାଲି amend କରିବାକୁ କହୁଛି
IN number 200 this is an application for amendment ସେଗୁଡ଼ା objection କିଛି କରୁନାହାନ୍ତି ଆଉ କିଛି କରିବେ କି ଆଉ ତ ସେ ଆପଣ Learned Council for the opposite parties have been solved with the copy of the interim application, and after going through the same, he has no objection to the prayer for amendment, considering the submission made by the land council for the respective parties and the government's taken in the interim application. Prayer in the IA is allowed. Now the proposed amendments are formed the part of the writ petition, and consolidated writ petition be filed by Debe.
I have already replaced that page only. Only 3 lines have to finish.
No, अशी prayer portion है तो prayer portion टा देबे ना.
Only file person. That will take a record.
क्या हुआ फाइल कले
कोठी
जाना दिस सर्कुलर टा हमर आउ फाइल कर दिबे जहा गुरु करथुल आउ करिबे unless at your amendment is allowed. How can you file in advance?
Where is that कोई इटा फाइल कर दीजिए. ओहो ते पेज रे जो 13 नंबर पेज रे 3 was taken रो अछि तो स्टार्ट है कि
that 3 lines I have to
ठीक है पेज नंबर 13 को आसिला एटा सेटा गला आउथरे सेटा जोटा फाइल को जन तदरे पेज नंबर 13 ठीक है. He has filed the page number 13 inserting the proposed amendment. Accordingly, the page number 13 is accepted, and digital record and it be substituted in place of the page number 13. What further you want?
This matter may be listed.
And you have given the copy. The copy of the page number 13 amended also has also been page number 13 containing the amended prayer portion has also been solved on the land council for the opposite party. Yes, then it has to, this IA is disposed of further.
This matter may come for admission.
Admission. List this matter under the heading of admission in the week commencing from 7th April 2020.
Okay.
I am appealing all the appeal.
Acha, Mr. Bhavani Shankar Raiguru, senior panel counsel, appears for all the opposite parties. 7/4/2025 admission. Yes, next.
Item 40.
Mr. Srinivas Satpathy, not there. The non-appears for adjourn for this. कोटा मेंशन करते ले कोटा
36
हां डिफेक्ट कोडा कोन रिमूव करना थी 36 रे आईए फॉर सब कोन इज ऑर्डर टा लास्ट टाइम
substitution filings miscase OP3 died.
नोटिस जाई छी
एटा जाई substitution पर जाए substitute file is allowed. That may be allowed and issue notice.
These are all private opposite parties.
Yes, boss.
So what is this writ petition?
Writ petition regarding the land dispute, the ancestral property, and
no, how is writ is maintainable?
Because it's the challenging the commissioner order of the first.
So who has died according to
OP3? Ismail Sahaj.
So in the main matter, notice has been issued.
Yes, sir. It is appearing from
where is it?
appearing.
Mr. Bose is there.
Yes.
He is appearing for all the opposite party.
All the opposite party except the OPC.
But he is not there unless we. Have you served a copy of your interim application?
ଆଗରୁ ସେ appear କରିଥିଲେ ସେ ଜାଣିଛନ୍ତି
ଓ ଆପଣ ଗୋଟେ application ଦଉଛନ୍ତି for substitution of legal
ସେ ଜାଣିଛନ୍ତି ସେ ଜାଣିଛନ୍ତି ଗୋଟେ କପି
ଜାଣିଛନ୍ତି କଣ ଏଟା ଘରୋଇ କଥା ଭଳିଆ କହୁଛନ୍ତି ଆପଣ ଦେଖନ୍ତୁ you serve a copy and since he is not there we take up some other day.
ଆପଣଙ୍କୁ ଗୋଟିଏ ପ୍ରଶ୍ନ ପଚାରିଲା ଆପଣ କପି ଦେଇଛନ୍ତି ହଁ କି ନାହିଁ କହିବେ ସେ ଜାଣିଛନ୍ତି ଆଗରୁ appear କରିଛନ୍ତି ପରେ ବି appear କରିବେ ଏତେ କଥା ଆମେ ପଚାରୁଛୁ ଆପଣଙ୍କୁ
ଦେଖନ୍ତୁ the IN number so and so this is an application for substitution of legal representative of opposite party number 3. The land council for the opposite party petitioner submits that you have not served the copy.
IR copy ଦେଇଛନ୍ତି କି
ସେ କଥା କହୁନାହାନ୍ତି ମାନେ you are not sure. Let a copy of the interim application be served on the land council for the opposite parties. है ना? Put up this matter in the week commencing from 7th of April 2025. है ना? ये जो IN number 1801523 तारी कॉपी टे देवे मिस्टर बोस ना लिखिबेनी लैंड काउंसिल फॉर द ऑपोजिट पार्टीज को समस्त ପାଇଁ appear କରୁଛନ୍ତି है ना मैटर आसियो 7 तारिख 7/4/2025
Lord, see, I think she is not appearing this opposite party.
I think ना प्राची
That's why I am praying for a issue notice to the opposite party.
मेरा मान महाजी कहीं बोस अपील कर जी नामा सोई जी नामा देखो जी मेरा मान महाज सहाज
brief has been transferred.
ओपन नंबर 4 नहीं अपील कर सर
Yes. Open number 4 by Mr. Ambud Bose is appearing.
So what about the others?
Others
notice जदी जाइथिला
they are not appearing.
So interim application so let it come we will let us let because Mr. Bose is not there 7 तारीख को
The interim order is there. The interim order is there. Continue.
What interim order?
They are going to
which is on which date the interim order has been passed?
Earlier date.
Who तारीख है status still the next date of hearing এটা ହେଇଥିଲା order dated 19/4/2023
ତାପରେ ତ ଆଉ ଇଏ କରନି extension ହେଇନି
no yes
so status को order pass ହେଇଥିଲା on 19/4/2023 ତାପରେ ସେଟା extension ହେଇନି so who knows that what has happened thereafter କାରଣ status को date ଥିଲା 10/5/2023 पर्यंत next date of hearing ଥିଲା
list
हां
list ಯಾವ ହେଇନି
ତ 9/11 list ହେଇଥିଲା ପୁରା
9/11/2023 ରେ list ହେଲା ଆପଣ କହିଲେନି ଯେ status को order ଟା continue କरा ବୋଲି
ସେଇଟା ସାର୍ ହେଇଥିଲା ତାପରେ
अरे बाबू कौन सी
କିଛି ବୁଝୁନାହାନ୍ତି 9/11/23 ରେ ସେ interim order ଟା extend ହେଲାନି you have not filed any application for continuance of the interim order we are in 2025
we do not know that what might have happened so how will pass an order that the status quo order to continue if it was there for a particular date that date thereafter the matter was listed and status quo order was not extended now after 2 years how will pass that order
in the meantime matter was not
date of hearing
taken up
till the next date of hearing not next date
you do one thing you file an interim application to extend that
for extension of interim
extension of that status quo order interim order है ना हम तो आणुछु मैटर ता 7 तारिख दिन ता भीतर फाइल करनु ब्रेक हेले interim order break हे गेले असुविधा हो है ना ई बात सही है
गोटे पास वर्तला गोटे राखी दियो हां
Pass over item number 22.
Anukya after
adjournment no you are asking adjournment for Namita Patnaik on behalf
yes sir
what is your good name
I am there my power is there also DP Das
Mr. DP Das land council appearing for the petitioner 6 for adjournment कितने समय दरकार
1 week after
no interim order is there
first time as
21/4/2025 ना
Item 6 in today's list minutes. Actually, that may be taken up tomorrow because Mr. Panda is not, he cannot make an appearance before Justice Mishra matters of concerned.
Want to mention that one idea for interim bailments.
Supplemental list, item number 1. Item 2. Item 3.
My lord, under Mr. Deepak Sharma, I prepare adjournment. The meantime, he has surrendered, my lord. Not yet received. 25 to 25 he has surrendered.
We are giving you time.
Yes.
Yes.
Item 4.
Same order, my lord. Yes.
Item 5.
Item 5, my lord. I'm sorry I couldn't appear yesterday because of the internet disruption, my lord. But actually, I have been provided the judgment of the learned trial court. Paper book I have not received. I'll collect the paper book, Your Lordship.
This petition has been filed.
My lord.
After special campaign.
Lordship. Yes, yes.
So they have stated that if somebody is
70 years or any disease.
is suffering from terminal.
Yes.
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 Then he can be released.
As per the judgment, my lord, he is it about 68 years.
He is around.
Now, my lord, 68. At the time of judgment, that is 2018, he was 60 years. My lord. My lord.
The report is there. Nalsa's report is there. That says 7. Nalsa, Your Lordship, page 78 of the liquid report. No, Lordship, there is a report in the proper format by the Nalsa, which says the agent is the accused is about 72 years. That is on page 78.
Yes, but as per the judgment, 68. 72 years. 70. But yes, but as per the judgment, if your lordship says 68 is the date.
That is the
report, your lordship.
It is the prisoner report given by the Nalsa Illicit. That is at page 78 of the brief.
You have seen just the instruction about the criminal act incident. What do you want further, Mr. So?
Copy of the depositions, lord. It is based on only the statement of PW5. Yes, I'll collect your lordship. Lordship. I'll collect pen drive, lordship.
submits that is not having the petition copies of the witnesses. The petition copies is applied by the master. The current council.
Ebbe naik guy. Ah, yes. Right. Worship.
These are camping on food business and primary. The report indicates that the appellant is now said about
7 to column number 4, your lordship.
There are 7. But the judgment might not.
Judgmental is 68 ho, but the report says 7.
Foreign council for the state board, and even Mishra Australia for 8 years, 11 months, and 2 years. I think good data. That council for the state that of the discussion about the timber and the state against the upland. We are beginning to 15 and March 23 of the yes.
And can you be on 16th, your lordship? 16th. Great, your lordship.
Item 7.
First, the instruction was sought regarding the status of the cases. Having 135 cases out of which 95 cases is in active. In the instructions are only this. I only out of sending a change. 12টা কেসে ডিফল্ট বেল রেখেছে 12টা কেসে বেল রেখেছে যেন 2 for defending us.
That would be involved in 135 cases.
But Lordship, I have not been convicted in any of the cases. I'm acquitted in as many as 95 cases.
And in the instant case in which I am being convicted, there also evidence is very weak.
Supported and you got convicted. But in all other cases, they are not supporting.
Instant this case also, Lordship, the scheduled offense of NIA Act 120. Yes, sir. Despite that, the trial was not
cases that on scene, police entered into the house by breaking the room that is judgment page number 2.
Yes, sir.
On the door and giving reasonable time and opportunity to be. But on seeing the police team, Sabyasachi Pandit tried to fire from his revolver and also push the police team in an attempt to.
No fired bullet is seized from the spot.
For the
Not
revolver, once to USA having been so live ammunition, gas of rupees 2 lakhs, so many things have been seized.
But your Lordship,
revolver, USA rock, apart from other things.
the revolver cartridges are not marked as material object during the trial. Most important is this chapter 6 is the schedule offense of NIA, and the trial, the cognizance of it is taken by learned SDJ, which should not have taken. Then the trial.
State has produced the book on the that out of the 122 pages constituted against the petition, that the report of the senior superintendents are clearly announced. That 35 cases he has been admitted in all the cases. Out of the 35 cases, the petitioner has been reached on bail in 6 cases, which are subject to for JMHC Solar. And this case he has been convicted, and various cases are sessions trial cases. Which are pending either in the session judge court or in the additional session judge court. One case is pending before the actions. The report furnished by the Guidance Council for the state is economic. In view of the available material of record by council for the party, the material of record, particularly the criminal proclivity of the petitioner, we are not inclined to release the petitioner on the stance in the case is of the year 2019 and the report has already declared matter being carried within this two after collaboration.
Item number 8.
Madam, we have a we will take care of next week. In the meantime, we'll file the deposit. Satyajit Raut.
That council contains the sister and adjournments. Finding the different officer in the Grand Council for the state.
Item number 9.
May I please, my lord, the petition has filed. I am the appealing for the appellant, my lord. Filed the bail petition, my lord.
How many appellants are there?
My sole appellants, my lord. One. Yes, my lord. Yes, my lord. Already interim bail already surrendered, my lord. My lord, the allowed, my lord. Yes. Yes,
another is for 85 of 24 for 50.
One bail application.
Then file another bail application.
মানে consent পরে appear করলি consent not press one bail application and not press, my lord.
I.M. 43 of 2020. The application for bail. Private counsel for fee and one to create which application.
Yes,
now I.M. number 85 of 2020.
yes, my lord.
So have you been released or rejected your bail application under this court?
No, rejected, no rejected. Interim bail allowed, my lord. Already, sir.
If we include the judge.
Out of date. And they
Under welcome employee.
bail interim bail, my lord.
Order the pound, you
6/2/2025, my lord. Certified custody certificate, my lord. Order dated 2011-2024. London Council of State has filed the custody certificate. Custody certificate, lordship can see 6/2/2020. Yes, ma'am. As my lord, the 6/2/2025 order, my lord. Kindly see. No, my lord. Say then a file correction the custody certificate, my lord. Yes, my lord. Lordship kindly next week.
Deposition copy may be subscribed. They are not. Deposition copy.
Pen drive with yes, ma'am.
Current counsel for the current also current counsel for the state service that they are not having the petition possible there. And since that report is available, then will be announced the petition for the expectation that the particular the petition office and the witnesses to be current counsel for the party of the yes, and I remember on the voice the IAM for bail. To go to it and we'll take off this matter on 21st of April.
Yes, yes.
Obtain of this the answer to the matter that's why you have to
Item number 10.
Yes, my lord. Yes, Mr. Counsel. My lord. You have made a submission. Why do you not verify the record? The custody certificate is available and it is
Sorry.
from the superintendent Circumstantial Hon'Ble, and the report indicates that the day from which you are taken into custody
Your never released on bail. And you would column interim bail period if any, that actually nine. ଆପଣ ଯାଇନାହାନ୍ତି ଆପଣ
ସରି ମାଇ ଲର୍ଡ ମୁଁ କହିଛି ମୁଁ ଆଇଏଫଆଇ ନା କନସେଣ୍ଟ
ଆଚ୍ଛା 2024 ର ଯୋଉଟା ଆପଣ ପରେ ପାଇଛନ୍ତି ସେଇଥିରେ ନିଜେ ଲେଖିଲେ ଏଟା ନିଜେ କରିଛନ୍ତି ନା ଆଉ କିଏ ଲେଖିଛି
ସରି ମାଇ ଲର୍ଡ ମୋତେ ଦେଖିଲା ନେକ୍ସଟ
Item number 10.
Please, my lord. This appeal my lord filed IA for bail, my lord. The present appellant may have convicted under section 302. Though charge has been framed under section 498 to 302, 34 IPC, and convicted under section 302 for life, my lord.
And for the eviction copy,
I received.
What are the offenses?
302, 498 is 302, 34 IPC.
And Sabita Guni, they were found not guilty. Under section 302 by 34 accurate, but they have been found guilty under DO and sentenced to imprisonment for life. This is true. So, you along some of the coercive persons. Who are those coercive persons?
My lord, the father and
mother. They face trial under 302 by 34 IPC. So the deceased is Ranju wife, Ranju Naik. So, how she died? Case of burn
injury. And she lodged a FIR. Deceased lodged a FIR.
What she stated in the past?
As per allegation, FIR allegation, occurrence took place on 10/5/2012. Occurrence 10/5/12 and death was 18/8/12. 10/5/12. Four 7/2012. 18/8/2012. More than here about 3 months.
You portion of refugee. Doctor March 2012 fire. ରାତି ପ୍ରାୟ 2ଟା ସମୟରେ ଶୋଇବା ଅବସ୍ଥାରେ ମୋ ସ୍ୱାମୀ ମୋ ଦେହରେ ନିଆଁ ଲଗାଇଥିଲେ ମୁଁ ବଞ୍ଚାଅ ବଞ୍ଚାଅ ବୋଲି ଚିତ୍କାର କଲି ମୋ ସ୍ୱାମୀ ଶାଶୁ ଶ୍ୱଶୁର ଠିଆ ହୋଇ ଦେଖୁଥିଲେ ମାତ୍ର ନିଆଁ ଲିଭେଇଲେ ନାହିଁ ଲୁଗାପଟା ସବୁ ପୋଡ଼ିଯିବା ପରେ ମୋତେ ନେଇ ଡାକ୍ତରଖାନାରେ ଭର୍ତ୍ତି କଲେ ଡାକ୍ତରଖାନାରୁ ଆଜି ଆଣି ମୋ सामने कोर्ट स्वामी स्वामी
Number 11.
Acha, but there is an application for stay of realization of fine. It is to be allowed. Yes.
Hello. I filed an interim application.
Yeah.
I filed an interim application. Because earlier twice his application was rejected. Now I have filed an interim application on the ground that his father-in-law has died and his rituals is 14 days rituals is no more valid.
It is a 40 days ritual.
Yes.
So the date took place on 17/2/2025.
So death दिन तक किसी माने पहुंची हुई नहीं 40 days रे rituals हुए तो এটা আছে কাল all the since like 11 दिन যেମିତି ହୁଏ some 40 days ରେ rituals हुए
Yes. So what is your instruction on this interim application?
एडवांस से कॉपी सॉल्व कर देती
So सरपंच रो ଗୋଟେ सर्टिफिकेट अछि ऑथेंटिसिटी ऊपर इंस्ट्रक्शन नहीं होतो
इंस्ट्रक्शन के
आउ से जो कहउछनी कोन 40 दिन जो थाए सेटा से विषय भी इंस्ट्रक्शन नहीं जान
काली की अछि
कितने दिन पर्यंत कोन हुए 40 डेज माने कोन
40 होची 40 डेज रे एंती गरीब को माने एंती
40th day on the death.
आया
40 ना 40 days
40 days ना ना 40th days रे
40th day हां
से दिन रे जेंती ब्राह्मण को हमर से खाइबा को दियंती
नहीं माने व्हाट इज दी माने अन्य दिन रे किछ हुएनी
अन्य दिन रे होइनी माने ताको माने मरला पर ताको दफन कवर देला पर तापर आ किछि होइनी रिचुअल्स ता 40 days रे जाय कि रिचुअल्स समस्त परिवार लोक गरीब लोक आसंती ताको गरीब को लुगा पटा दिया ख्या पे
that would be on 40th day
40 days सेतरे जेहेतु जॉइन प्रेजेंस ता ठीक है
so 40th day न करी 40 days कहउछंती we are confused
हां ना 40th days 40 ता मधे 40 ताकू कोंती 40 आ सेतरे हम एथरे जेंती माने जे हिंदू ब्राह्मण प्रेजेंस माने नंडा बाय सो बहुत रिचुअल्स मोर सेमती किछि रिचुअल्स नाही जे माने मैन किंतु सम परिवार लोक समस्त जानते खाया पिया ताकू गरीब दान दान ए सब रहउछि रिचुअल्स ता
तो आपन काली ठुपरा देइथिले
कॉपीटा दे देथिले रिसीव एडवांस से देथिले earlier he was on bail
no that's all right
yes.
You are taking a ground but that is to be verified
yeah
26 तारिख फाइल करछन
so you get instruction today and we'll see that tomorrow next
item 12
I will look at the reason application for interim bail on the ground of the date of the father the petitioner run counsel for the state has received the copy of the interim application and submit that the matter may be taken off tomorrow. Leave this matter tomorrow for Rajgati for you. Upon नहीं जानते आज instruction आ जाए.
On behalf of Santosh Mahathi, I am speaking here. Lord, case is 302 Lord. And the custody Lord 29/9/2018. Custody certificate also attached to Lord.
Who attached could be? Interim application?
No, that is BLFL, sorry, IA 2036 of 2023 for bail, Lord.
Narasimha Pujari.
Yes, Lord.
ତାର custody certificate ଟା ଦେଖଉଛି ସେଟା କେବେ ଜାଣ 9/1/2025 ତାର ପିରିୟଡ ହଉଛି 2293 ଦିନ। 2293 365 ଧରିଲେ 6 years କେତେ ହବ ନା ନାହିଁ?
29/9/2018।
ଆରେ ବିଟୁରା ଡେଟ୍ ଆସିଛି 2293 ଦିନ ଟୋଟାଲ ହେଇଛି ଆପଣଙ୍କର ଏ ବି ସି ମିଶିକିନି।
ଏଠି ମଧ୍ୟ ଆରେଷ୍ଟ ଡେଟ୍ ଟା ଲେଖା ଅଛି ତ।
Hmm. 6 years sum up.
Milord.
So you have never been
No,
released on bail.
No, Milord.
What is the offense under which you are found guilty?
Milord, 302, Milord. And PW2 is the informant and eyewitness was one. PW5, Bida Kunjami.
What is the name of the deceased?
This is Kusuma Pujari. And present petitioner is the husband of the present appellant is the husband of the deceased, Milord. Kusuma Pujari.
Appellant is a husband.
Yes, Milord.
Date of occurrence is?
Date of occurrence is
21/2017.
Yes, Milord. 21/2017. PW2 is the informant. He is stating in chief that one Raghunath Pradhani and Bida Kunjami stated that.
Let us see that eyewitness statement. PW1.
PW5, Bida Kunjami.
Yes, sir. PW5 eyewitness. On the date of occurrence, I had gone with the cattle to Danger Land. Dangor Land.
Dongor Land.
Dongor Land for 10 days. And in the afternoon, I was returning home on
Puruna Pani Jungle Road. The accused, having killed the deceased, was sitting there near the head of the deceased, and he was crying by telling he killed his wife. He had killed the deceased by means of a rock. The accused had requested me not to disclose the fact to any other person.
The eyewitness to Brazil. Is the post occurrence witness.
But the informant
you are found present by the side of your wife and you are crying. Dead body seat thila na kon?
Dead body seat thila. Hali informant coach he is eyewitness, but he is not an eyewitness. In cross examination, he has stated that I was passing across the dead body, Milord. Say PW5 je. Chief re coach ita. But in cross examination, stating that I was passing across the dead body, but I did not go very close to the dead body. The dead body was lying under a sal tree. It was a footpath. I had seen the rocks lying there, but I had not identified.
This witness is not a witness, but he is a witness to the extrajudicial conflict.
Milord.
Hello?
Yes, Milord.
What else is there against you?
Not only that, Milord.
11. Puji?
On that day, I was 11. I know the Honorable Pujari, the informant, the district Pujari, and the accused. On that day, I was sitting with the ceremony of my daughter, and thereafter, I had fulfilled some liquor for and putting out the gate. The accused came to my house and finding liquor. For having finding liquor, the accused told he had killed his wife. Further, he came there and he told.
It was say extrajudicial construction. So there is no eyewitness to that based on extrajudicial construction.
Doctor number PW1.
PW1 Doctor.
The injury were the anti-mortem nature and cause of death was due to the internal and external injuries leading to the shock, common death. And the paragraph 5, in 49 of 2018, the police had produced one stone with a clarification. The stone had sharp edge. On exemption, I opined that the injury could have been caused by the said stone as the weapon of offense and normal offense of the weapon may be faulted.
And in 6, my lord, I do not find here the said weapon of offense, my lord. Doctor statement in paragraph 6. I cannot say the length and width of the offense. The injuries are possible by fall on stony surface, but with great force. Police officer had not examined me, my lord.
You are on bail during trial?
No, my lord.
So when you are taken into custody?
29/9/2018.
Say, Mr. Land counsel for the petitioner, land counsel for the state, the land counsel for the petitioner submits that the petitioner is in judicial custody since 29/9/2018. And as such, the remaining custody for 6.5 years. The occurrence in question took place on 21/6/2017, and there are no eyewitnesses to the occurrence. The main circumstance available on record against the petitioner is the extrajudicial confession stated to have been made before PW 5 and PW 11. And it is very difficult to accept such evidence. And therefore, there are no chances of success in the appeal, and balance of convenience is in favor of the petitioner. There is no likelihood of the appeal being taken up for early hearing. Therefore, the bail application may be favorably considered. Land counsel for the state On the other hand, oppose the prayer for bail face the evidence of PW5 and PW11. So also the doctor bracketed PW1 conducted post-mortem examination and noticed a lacerated wound on the temporomandibular region of the right side and opined the cause of death of the deceased due to internal and external hemorrhage leading to shock and death. Considering the submission made by the land counsel for the respective parties, nature of evidence available on record, absence of any direct evidence, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes. Public.
13.
Article 13.987.
Yes.
Conviction under section 302 and sentence to imprisonment for life and fine of rupees 10,000 ballots. Date of offense is 22/8/2020, my lord. And I'm in custody since 25/8/2020. Lords, and the case is based on circumstantial evidence, my lord. There is no direct evidence. My lord.
What are the circumstances?
My lord's extrajudicial confession, and my lord, last seen theory.
Extrajudicial confession before whom?
My lord, before PW 7 and 8, my lord. 4 villagers. And my lord, PW 16 has been cited as a star witness. PW 16 have been cited as a star witness.
PW 16.
My lord.
What he has stated?
My lord, last seen theory is with PW.
Last seen is PW 16 only, yes, or any other?
PW 16 only.
Okay. And who is the doctor who conducted PM?
My lord, doctor is PW 18, my lord.
So let us come to the evidence of PW 18 first.
My lord.
The doctor.
Paper book running page number 75.
Hematoma is there on the scalp. Another hematoma is found. Probable cause of death is due to head injury. Okay.
My lords. Paragraph 7, my lords.
7.
My lords. It is a fact that all the injuries, as mentioned under subpoint number 2 of point number 2 in the second page of my autopsy report, Exhibit 7, are possible by sliding from a height resulting in hitting on a hard surface. It is a fact that the injury, as mentioned in subpoint number 1 in so and so, in the second page autopsy, is possible by falling on a grass and having stones.
Okay, now you come to the extrajudicial confession evidence.
Extrajudicial confession.
PW 7.
PW 7.
Read it out.
My lord, running page number 53 of the paper.
Please.
My lords. Chief, my lord, I know the informant brother who is the brother of the deceased Govinda. I know the accused Basanta Devari is standing before me. My lord, second point. The accused called me over phone at about 5:30 p.m. and asked me the phone number of the deceased and told him that I did not have his number. And Basanta, my lord, the present petitioner, told me that the deceased was lying in a dead in a jungle near a village, and his wife told about the same. Later I saw that. After that, my lord, PP had further examined. Paragraph number 3. My lord, 4 lines from the bottom. On the morning of the occurrence, the accused told me, here, my lord, the confession is there. Told me that the deceased was murdered, and that the accused told me that he had committed the murder of the deceased, my lords. This is the extrajudicial confession. My lord, in cross-examination, the lordship may come. Paragraph number 4.
Yes.
Except these facts, which the accused has told me, as I have mentioned earlier, I have not stated anything else to the IO in this case. One Ganeshwar Naik, my lord, PW 8, was also present when the accused told me that he had committed murder of the deceased by beating him to death. Now, PW8 is that Ganeshwar Naik, who was present as per PW7 minutes. That is in running page number 55. Paragraph number 2 in chief minutes. About 1 year back, I heard from people of my village that Vasanta had committed, he had heard it from that he had committed the murder of by a letter. I went to the spot where the deceased body was lying by the roadside.
PW16 is last scene.
PW16
quarreling.
My lord, PW16 is the last scene.
Relating to a bicycle,
My lords.
you are found quarreling with the deceased.
My lords. In cross-examination also. I was paragraph number 3. I was going on the road which was by the side of the pond, which was a large one. It is a fact that apart from the roadside, all other side of the pond was surrounded by forest. The accused and the deceased were quarreling on the other side of the road. I was going opposite side. I had not heard all the words that were being uttered.
The evidence of PW11 may clear para 3.
That he was quarreling with the deceased and he was quarreling relating to a bicycle.
Para 3 of page 262 PW11 may clear class. Prior to the 2 or 3 days occurrence, the accused has snatched away the bicycle of the deceased. Says bicycle of the recovery from the accused IO, page 86. Okay.
Accused of the deceased, they were quarreling with each other relating to a bicycle.
The bicycle accused ঘরু recovery ହେଇଛି.
ঠিক ଅଛି ଏଇ ଯୋଉ ଭିତରେ ଯୋଉ ପାଣି ହଉଥିଲା ସେଟା କୋଉଠି ହଉଥିଲା
ରାସ୍ତାରେ
ଏପରି କୋଉଠି ମିଳିଲା
ଡିଷ୍ଟାନ୍ସ ପ୍ଲେସ୍ ଅଲଗା ଜାଗାରେ
ଏପରି ଥିଲା ଗୋଟେ
ପଣ୍ଡ ପାଖରେ
ଆଜ୍ଞା ପଡା କଣ
ଆଜ୍ଞା
ସେଟା ତା ନେକ୍ସଟ ଡେ ଦିନ ମିଳିଲା
ଆଜ୍ଞା
ଦେଖି ସେଇ ନିଜେ କହୁଛି ହେଲା his dead body was lying near a pond and on the next day I heard it. So ଗୋଟିଏ ଜାଗାରେ ଆପଣ ଆଦିତ୍ୟ ପାଇଁ ପଡି ହଉଥିଲା ଏମିତି ବି ହେଇପାରେ ସେ ସାଇକେଲ ନେଇ ଚାଲିଗଲା ପରେ ଆଉ କାହାର ସଂସ୍ପର୍ଶରେ ସିଏ ଆସିପାରିଥାଏ ଆସିନ ଫଣ୍ଡାମେଣ୍ଟାଲ ଜିନିଷଟା ହଉଛି ଆପଣଙ୍କର
ଇଣ୍ଟରଭେନିଂ ରହିବା
ଯୋଉ ଜାଗାରେ ଆପଣ ଲାଷ୍ଟ ସିନ୍ ରହିଛି ସେଇ ପାଖାପାଖି ଆପଣ ଯଦି ଗୋଟେ ଦିନ ପରେ ତାର ଡେଥ୍ ହୋଇକି ଆଉ ଗୋଟେ ଜାଗାରେ ଗୋଟେ ପୋଖରୀ ପାଖରେ ମିଳିଲା ତାହେଲେ how can you rule out that nobody has come in contact with the deceased in the meantime after that quarrel and when the dead body was recovered?
Even that is the correct. The thing is that quarrel due to that cycle and 100 rupees taken. That cycle was recovered from the. That is not the statement in 330.
Therefore, suspecting the involvement of the accused with the death of patient by brother lawfully. So, given that once you suspect people, there is no question of
direct accusation. Direct accusation.
Suspicion. Suspicion is how to be likely. The Sanjay was likely that party if you want.
যেহেতু প্রায় ଗାଁରେ ଆଜ୍ଞା ଗାଁରେ 100 ଟଙ୍କା ସାଇକେଲ that is the ଗାଁରେ 100 ଟଙ୍କା ସାଇକେଲ that is the
and asked me the phone number of the deceased and told me that I did not have the phone number of person. Told me that deceased was lying dead on Zoom. He has been declared hostile by the public prosecutor. And public prosecutor Pachal she तारा confront करा 161 जे तमे IO पाकरी ही है ना so that is not the substantive evidence she कहना कोर्ट रे से जिंस को नहीं सीधा Pachal जे तमे IO पाकरी ही है कोई नहीं ठीक है इसी में हम IO पाकरी से आते but कोर्ट रे तार evidence जो होगा तो फोन कथा कोई इधर she mentioned there is nothing that the receipt has the applicant has made extrajudicial
extrajudicial
up to the evidence of the PW8
only last thing extrajudicial motive 160 पर record है that has also not creating any link that is also
PW8 मतलब
same thing
even that is hard to be people of the that was on the committed murder after that hostile declare करे hostile declare करे इन बोलने ने हम पुलिस पार्टी को कहला जे जेतु
it is a fact
तुमको तारीख बोलला ସେଥିପାଇଁ ତମେ ତାକୁ ମାରି ବୋଲି କହୁଥିଲ
it is a next कहती it is a para 2 FS2 para 3 last part it is a fact that schedule 8 I have stated before IO that on 23/20 the morning the accused told me that he had assaulted the deceased
so this is the statement and let us say that he has made such a statement before the police but in court what is the statement the এটা কোনো ডিক্লেয়ার করে ঘোষণা করি তাকে ঠিক আইলে যে কোনো 161 এ ডিআর করিছিল 161 is not a substantive evidence but what is stated in chief examination
that corroboration institute
the police statement or the land council for the petition and council for the state the land council for the petitioner submits that the petitioner is in judicial custody since February
25/8/2020 मतलब
judgment to the
judgment रो second page रे
column number 3
police is
25/8
2020 and the case is based on circumstantial evidence and PW7 and 8 so far as extrajudicial completion is concerned and PW16 so far as last scene of the apparent in the company the receipt is concerned but their evidence is very shaky in nature and PW7 and PW8 have not stated that they have hard extrajudicial completion of the apparent who have killed the deceased and therefore both of them were declared hostile by the prosecution and after being declared hostile the previous statement of these witnesses recorded under section 161 CRPC were confronted to them and that is how the 161 statements have been utilized as substantive evidence in this case. So far as PW16 is concerned, he has stated to have seen the appellant and the deceased quarreling at one place relating to a bicycle and the same witness came to know subsequently that on the next day that the dead body of the deceased was lying near a pond in Korangia. Therefore, there is no proximate link between the work and the place where place of work and the place where the dead body was recovered, and therefore there are good chances of success in the appeal and balance of convenience is in favor of the appellant. And since there is no chance of arguing, the application may be favorably considered. When counsel for the state, on the other hand, oppose the prayer for the evidence of P.W. 7, 8, P.W. 16. Also, the evidence of the doctor, bracket P.W. 18, was opined that the cause of death of the deceased was due to head injury. The counsel for the state further submits that the cycle for which the work was made sealed by P.W. 16 was recovered at the instance of the appellant. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during the absence of any direct evidence, even the intention of the petition and the petition absence of any chance of early hearing, we are inclined to release the petition on the
I'm grateful, man. I'm grateful.
No, 14.
On behalf of Mr. Saugadas, I adjournment.
What is your name?
Sommer Palanga, Salim.
Power in this case?
No.
Also appearing for the Saugadas 6 parameter. Is this matter? किसी पहले हम साथ में पाऊंगी बात पहले ये adjournment नंबर 5
Sir, sir, मैं कोई जानती हूँ बताना.
आप से पहले 700
Item 15.
Item 15 pass.
Item 16.
Item 16, on behalf of Mr. Rao, kindly adjourn to next.
Item 17.
Suggestion for all. What is this matter?
302. So FR named in FR. No, my lord.
Copy is not.
Copy. Yes. No, no, no.
Item 18.
May I please? And the applicant was convicted on section 302 and sentenced to undergo for 302 and my lord 201 and to sentence to under yes please. P02, 201 and 34 IPs. Circumstantial evidence. Man. Circumstances is that the deceased was went to both over phone he has stated to his elder sister that he is going to meet his husband. And the occurrence took place, alleged occurrence took place on 2/9/2022. 22. As per FIR allegation, my lord,
What is the name of the deceased?
Sukko Luha,
That's clear.
Jio, white.
For Luha, you white.
Yes, ma'am.
Such a very detailed chart.
The on 6/9/2022. Do we know ସେମାନେ ଆଲିଜ କହୁଛନ୍ତି ଯେ ସେଇ ଦିନଠୁ ସେ ମିସିଂ ଥିଲା ବୋଲି 2 ରେ ମାନେ ଯାଇଥିଲେ ମେଡିକାଲ କୁ ସେ 3 sisters PW3 PW4 and PW21. These 3 are elder sisters of the deceased. PW4 and PW21. 21 along with deceased they went to medical.
Sisters of the deceased.
After checkup, they returned to home and the deceased told them that I am going to both. After that, he did not respond to his phone. And on 6/9/2022, a dead body of a woman has been traced out from an abandoned well, which is near under the Bansuni police station, that is Sitapur.
And that was identified to be the
deceased.
All right. This is one thing. What are the links that you were committed in murder?
There is no link.
Direct evidence is circumstantial evidence कौन करेगा?
Circumstantial for the first time the FIR was lodged against unknown person. And during investigation, 2 persons are arrested. The petitioner and another co-accused Ramakant Naik. As per the prosecution story, my lord, the informant who is the PW3, my lord, he has stated that the deceased went there. Since the deceased is the second wife of the appellant, there was quarrel between them. In the meantime, for which reason she has stayed at her house. And so far as conduct is relating to conduct of the appellant, she stated that we intimated the appellant to present in the funeral ceremony, but she didn't respond. But the father of the deceased, who is examined as PW 18 manner, she stated that we have never intimated the accused regarding death of the deceased.
May I? PW3, 4 and 21. So the evidence of the PW3, 4 and 21 may I place it? This କହିକି ଯାଇଛି ଆଜ୍ଞା ଆଗରୁ କହୁଛନ୍ତି ସେ ତାକୁ ବାଡଉଥିଲା ଏମାନେ ତାର ଇଞ୍ଜୁରି ଦେଖିଛନ୍ତି ବଡିରେ that was inflicted by the appellant. That shows the motive and the that was treated as a dying declaration. The last call was made to the PW21 by the deceased, who said that she is going to go to meet appellant. Okay. मते कॉल करथिला जिबा पे मो जाईची. And then she was found missing.
What is the proof that I have reached to my husband's house?
There is no proof that ମାନେ ବସ ରେ ବସେଇ PW21 ଏମାନେ ତାକୁ ବସ ରେ ବସେଇଛନ୍ତି PW21 ତାକୁ ବସ ରେ ବସେଇଛନ୍ତି ବୋଥ ପାଇଁ ତାପରେ then she did not respond to any calls then PW21 କହୁଛି ମାନେ the last call which made to deceased ସେ କହିଲା ଯେ ମୁଁ ଅଛି appellant ପାଖରେ ବୋଲି may I place the PW21 yes. I'll place PW3 for unpending. I'll start with PW20 may I informant is my elder sister. Deceased is my younger sister. I know both the accused persons standing in the door. I got the news. PW21. Informant is my elder sister. Deceased is my younger sister. I know both the accused persons standing in the door. I got the news relating to death of my sister on 6/9/22. I came to know that she died at Bausuni Sitapur Jungle on 2/9/22. I, along with informant and the deceased, had come to Reraful Hospital for the treatment of informant and the deceased. The husband of the deceased, namely Nirmala Luha, contacted her over phone to come to Bodh. I also heard from the talk of the deceased and that the deceased intimated him no bus available at the present to reach Bodh, and thereafter Nirmal told her about his coming to Bodh to take her back. Leaving deceased there, myself and informant boarded the bus to reach our village. We reached at 5:30 p.m. I rang deceased at 6 p.m. but she did not receive, and again on further call she attended the same. Deceased told that she was with Nirmal Luha and decided not to return to village, rather to stay with Nirmal Luha. The accused Nirmal Luha took the mobile of the deceased and informed me that he will come with the deceased on the next day. Both did not turn up on the next day. Despite my repeated call to deceased, it is found in switched off state. I also tried to contact Nirmal Luha, but he also did not receive my call. After 2 days, I had come to Rerakul Medical due to my health problem. At medical, I got the information from my voucher that police had came to our house and informed to come to the village of Sitapur under Bausuni PS to identify a dead body which was floating inside a well as to whether the same belongs to your family or not. We all the family members came to the aforesaid spot and identified the dead body of my sister. When we found the dead body of my sister was already brought outside. Further, we found the bag which was taken was in her bag. We also found big stone was tied in her waist by one dowdy. Dead body was decomposed state and maggots seen all over the body. On my phone to accuse Nirmala Luha about the death of the deceased, he told to hand over her death certificate. He did not come to attend the funeral ceremony of the deceased despite of her intimation. I had knowledge about quarrel between the deceased with Nirmala Luha prior to the incident. Prior to 15 days of the incident, both the accused persons had come to our house and threatened my sister saying, "Ebbe jibu to chal nahale jouthi rahile bhi maridu." We told before our family members the aforesaid. When we protested, both the accused person threatened samastanku bandi kari kuare pakedo.
Doctor is my PW7. PW7. PM. PW7. Two doctors are conducted the autopsy of the dead body. One doctor is examined as PW7 and prosecution failed to examine the other.
Three for the same version. 3 for the same version. ନାଇଁ ଏପଟେ ଶୁଣ ଏମାନେ ବି କଲ୍ କରିଥିଲେ ମୁଁ ଖାଲି PW3 ର paragraph 2 ଟା ଖାଲି ପ୍ଲେସ୍ କରିଦଉଛି PW3 is the sister of the deceased. On 2/9/22, myself, deceased, and other two sisters have come to Rerakul Hospital. I was not feeling well. Deceased told us to go to both with her husband. She left us and proceeded in a bus. When I rang her, she told that she was as because going with the husband Nirmal in a bike for which she will call call back after her reach. Thereafter, she did not make any ring to me. Despite I repeated call, she did not receive the same.
On second, the employee was recovered from the bed 3 days thereafter, on the 6th. But thereafter, nobody has seen the PC target.
Madam, in this format, the statement of the PW2, sorry, madam, informant PW3 and PW number, madam, 3, 4, and 21. These are, madam, contradictory to each other, madam.
Very good.
FIR, madam, FIR, they have not suspected also. For the first time in the court, I read the FIR. FIR, madam, 6, madam.
So, madam, authority to be required a lot. But the consensus for a lot. They don't have to have a boss proceeding for it. CGS on a moving must be fiber, most not flashy. Most of you can get a boss, was a or after our phone or line. You the Swami Koila, basically the degree, after CA Koila, Swami Pakarachi, the Swami Koila, Home Pakarachi, Sura subsidy, Kahila, is to be served. That's why only Likita,
Dita lines on a लिखिଛନ୍ତି both अभिमुखे
he was in the company of the appellant, which was stated by the deceased herself to them. Not only that, the appellant also performed to them that the deceased is my company. So if that is the state of affair, then FIR it should have been mentioned. There is nothing FIR is against unknown person.
FIR खाली मोटरसाइकेल रो आवाज सुबुतला और सोने किसी और लिखने हैं
aspect vital aspect you plead about the presence of the appellant. Second, please in the company. That is not there.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner about bail custody. The petitioner is in judicial custody since 8/9/2022. And the case is based on circumstantial evidence. And the evidence of PW3, PW4, and PW21, who are the three sisters of the deceased, indicate that the deceased told to them over phone that she was in the company of her husband, bracketary petitioner. And the petitioner also told them over phone that the deceased was in the company, in his company.
and therefore the evidence of these three witnesses in this respect has been utilized as the last scene of the two, and more particularly thereafter nobody has seen the deceased alive, and the dead body of the deceased was recovered on 6/9/2022 from an abandoned well. However, the first information report, which was lodged by PW3, does not indicate on 6 of 6/9/2022 does not indicate that the deceased stated before her that she was in the company of the appellant, nor appellant stated that the deceased was in his company. The Land Council submits that in view of the nature of evidence available on record, there are good chances of success, and the first information report was lost against unknown person, and therefore there are good chances of success in the appeal and balance of convenience in his favor, and since there is no chance of early hearing, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail, placed the evidence of PW3, PW4, and PW21. So also the evidence of PW7, the doctor who conducted post-mortem examination and opined the cause of death due to strangulation, and that the death was homicidal in nature. Considering the submission made by the Land Council for the respective party, in absence of any direct evidence, nature of circumstantial evidence on record, absence of any chance of early hearing, period of detention in judicial custody, we are inclined to release the petitioner on bail allowed. You come to yes.
Item 26 का admission
26
admit hearing 40 से
अच्छा लेट है कि 5 दिन condonation of delay petition filing
इसमें jail
condonation of IN number so on the JCRL number लिख दियो I-26 JCRL number 21 of 2020 this appeal from jail has been received 5 days after, late by 5 days है ना, since the petitioner has been sentenced to imprisonment for life.
Yes, sir.
Imprisonment for life under section 302 of the Indian Penal Code. We are inclined to condone the delay in filing this jail criminal appeal. Accordingly, delay is condoned. Hard admit call for the trial court record.
80 years old.
Stop. The bail application shall be considered after receipt of the trial court record. अच्छा এইটা তারপরে 25 নম্বরটা দেখନ୍ତୁ ହେଲା ସେ ଯୋଉ ডিলে ରହିଛି 8 ଦିନ ডিଲେ କନନ କରିଦେବେ ଆଡମିଟ କରିଦେବେ ହେଲା ସେ ମୁଁ ଲିଷ୍ଟ ଦେଖିଲେ ମୁଁ ଜଣକୁ ଏନଗେଜ କରିଦେବି ତା ଉପରଟା ଦେଖନ୍ତୁ 24 ନମ୍ବର ସେମିତି 10 ଦିନ ବିଳମ୍ବ ରହିଛି डिले कनन କରିଦେବେ ସେଗୁଡାକ ସବୁ ଲେଖିବେ that these are all sentence to life imprisonment ଦେଖିଦବା हाँ 302 life imprisonment একটা ହେଲା 40টা ଦେଖିବା ତା ପୂର୍ବର ପରଟା ତବି life imprisonment ଦେଖ हाँ life imprisonment ठीक है तो डिले कनन बाकी सेटा एडमिट कर देवे है ना एंड trial court record so and so is engaged the पठेदेली ଗୋଟେ slip ରେ engaged and intimate the land intimate the appellant about the engagement of the counsel. ତାପରେ
Item 19, Your Lordship.
wait. Item number 23. এটা লেখନ୍ତୁ. This appeal has been received from jail by late by 3585 days. Let the jail superintendent submit a report as to why the appeal was not preferred earlier. A report in that respect shall also be called for from the learned additional session judge Champua. Matter be listed in the week commencing from 21 April 2025. Pre-copy of the order be handed over to the learning council for the state. There is a that they used to district judge used to that CGM they used to visit
Every
the
month.
jail every month, and their first duty used to see that
Whether
if
any
all the
yes.
persons who have been convicted whether they have preferred an appeal or not.
Yes.
So this is virtually 10 years the appeal has not been filed. And also the jail superintendent duty is also there.
That is.
So why suppose he says that I will not file any appeal, matter is different, but that will come out and it may so happen that he might have given the papers to somebody and he might be under impression that my irregular criminal appeal has been filed. So that may be also, so you give that
yes.
Obtain that instruction and we are calling for the report.
Yes.
For the report, the file be placed before the Register General, Register Judicial, who shall call for a report from the London Trial Court by email for them. Baki, what about this one? Item number 22.
Your Lordship.
Confirmation of delay.
Yes, Your Lordship. There has been a 15 days of delay.
15 days.
Due to the financial constraint of the appellant, she could not approach.
What is your name?
Arushmita Acharya.
Anu?
Arushmita Acharya.
Arushmita Acharya. Heard Miss Arushmita Acharya, Learning Counsel for the appellant. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 16 days.
15 days, Your Lordship.
It is 16 days as per the SR. And since it's a case where the appellant has been sentenced to life imprisonment, after hearing the Learning Counsel for both the parties going through the averments taken in the interim application, we are inclined to condone the delay. Accordingly, delay is condoned. Hard admit call for the trial court report. Yes.
The item 21.
21. Why are you not coming to the court?
Your Lordship, due to some personal difficulty, I am not able to be present today.
Yes. Item 21.
There is 46 days delay.
First item da.
3 cases.
Tinta 46 days. Acha. First lekhundu. IA number so and so 46 days delay. Same like delay condone. Eta sab life imprisonment to?
Life imprisonment.
Delay condone hard admit call for the trial court report. Second ta dekidam 208 ta varkam. Delay ta dekhundu SR din. For 46 days same. है सब डिले condone admit এটা भी डिले condone admit हार्टটা भी দেখুন তো 209 দেখি দাও 209 ঠিক আছে সেম ডিলে condone है ना admit बाकी जोड़ा रहीगला सेटा कोई नहीं
My lord. Item 20, my lord.
Pardon, my lord. Item 19.
I pray on Tuesday. Tomorrow I will remain absent.
अच्छा তাহলে এই দুইটাক
19 টা মঙ্গলবার
নেক্সট উইক মে আসিব মঙ্গলবার
Item 20, my lords. Item 20 is to be not pressed, my lords.
Why?
My lords,
Here
this
one appeal was filed by the same appellant, which is on
this appeal, my lords, filed after 12 years, and there is in delay condemnation petition. But it is now come to knowledge that there was a previous appeal filed by the appellant 158/2013, my lords, and in that, my lords, LCR has been called for, and in that case also delay has been condoned, my lords.
And that is pending or disposed of?
That is pending. So under the impression that there is no other appeal,
CRLA number 123 of 2025, Mr. Rajendra Narayan Rao and counsel appearing through virtual mode submits that inadvertently this appeal has been filed, even though the appellant has preferred an appeal earlier in CRLA number 158 of 2013, which is sub judice before this court, and therefore he does not want to place this appeal. Accordingly, the CRLA, this criminal appeal is disposed of as not pressed for them. Yeah.